ಹಾ. Thank you.
Appearing for respondent, my lord. It's 2018 matter. We have filed IF for bringing.
One man for tomorrow. Contempt matter for tomorrow. No, memo I am going. Yes. That. Yes, very good.
Appearing for appearing for respondent, my lord. It's 2018 matter. We have filed IF for to bringing alerts. Some urgency is there, so post it. Yes, my lord.
Lordship's kindly. Lordship's kindly.
Yes.
Let's quote all one matter, Miller. Yes. Yes.
This is total one matter, ma'am. 23 writ appeal, admission for admission. Yes, ma'am. 23 matter. This is
RFA 21 matter. This court matter, madam, RFA 21, 2020. Yes, may be posted for a big group. Hearing. 21 matter, 2021. Huh?
The memo.
Prayer may be posted for hearing. Agency, my lord, I'm 76, I want to leave the profession.
He wants to retire. Yes.
Right.
Say memo for retirement.
No,
Sir.
for posted for hearing.
Sir, 2021 roasted. ಪಕ್ಕದ ಕೋರ್ಟ್
Second court ಅಂದ್ರೆ.
ಸರ್ ಪಕ್ಕದ ಕೋರ್ಟ್
Minutes, first court matter. Writ petition minutes pertains to medical admission minutes. The counseling minutes is scheduled on 24. Petitioner minutes have the claimed minutes are physically, the physical disability quota. The committee which has assessed minutes has assessed at 50%. In spite of that, minutes are not considered in the quota. The urgency is minutes, counseling is fixed on 24. If seats are allotted minutes, my writ petition becomes invalid. Minutes, the 24th minutes is the, yes. 23rd minutes is working, 23rd. Minutes, tomorrow, I am informed that minutes. Minutes, the registry informed that minutes, lordships in quota number 1 minutes are not sitting today and tomorrow. Minutes. Twenty-fourth minutes is something, I'll take a chance on it.
If I may, Your Honor. This is total one matter. I have filed an IF for modifying the interim order. There is some urgency because the workmen who are also the party to the writ petition. There's some urgency. Yes, Your Honor. 25th is the matter. 25th is the matter before the industrial tribunal. It has been stayed now. The properties are yet to be disposed of to pay off the workmen. It has been stayed by virtue of the impugned order.
Next. In the petition, I am the petitioner in this petition. The Honorable Court has added the state government advocate take the notice on behalf of the state and the private respondents, and immediately the matter. So it has not been listed. So is it of this court or court one? No, court or two. What is the number which you?
ಸರ್ RF
24.
ರಿಟ್ ಅಪೀಲ್ ಸರ್ ರಿಟ್ ಪಿಟಿಷನ್ ಸರ್
Your Lordship, this is pertaining to Group D employees of this Honorable Court, Dharwad Bench and Kalburgi. This is pertaining to Group D employees. Yeah.
ಇಲ್ಲ
PI.
PIL ಹೆಂಗ್ ಬರುತ್ತೆ ಸರ್ ಗ್ರೂಪ್ PIL ಹೆಂಗ್ ಬರುತ್ತೆ
My lord, it is the RFA of the year 2020. The suit is of the year 1992, my lord. It's a redemption suit. My lord, there's any week this time, there's some urgency. My lord, I am told that they have sold the property and that auction purchaser has also made the IA for impleading. And the matter was listed. Any day may be fixed, my lord. Yes,
Same, same, respondent number 3 in the same matter, your lordship. Yes, yes, your lordship.
My lords, total one matter, my lords. It's a writ appeal. My lords, appellant is a senior citizen, my lords. Gifted my property to my son and he has sold the property. Now subsequent purchaser, based on the impugned order. Please. My lords, please, please.
With your lordship's kind leave. With your lordship's kind leave. May I make submission, my lords?
Two. It's number 2, serial number 1.
Lords, one submission is there, my lords.
Yes.
In other day, on Friday, I moved a matter writ appeal for withdrawal. That has been listed under the hearing list today at serial number 78.
Sir, serial number?
78. It should have come in the order category under the for withdrawal.
Sir, list number 2, na sir? Sir, is it list number 2, sir?
List number, no, list number 2,
Serial number?
78.
78.
Wait.
It's serial number, list 2, serial number 1.
We will just give the dates in this. Just bear with us, we will call the numbers, we will immediately give the dates. Okay? Yes.
Serial number 1. P.N. Rajeshwar.
And permissions. Sorry, first quota number 1. Preliminary hearing, PAL matter.
What is this hearing?
Preliminary, fresh matters.
Yeah, just wait, just wait.
Make a.
First court matters.
Memo for.
I'm moving a memo for posting of tomorrow.
Yeah, have it day after tomorrow, mention it day after tomorrow. Before the chief. Yes.
Serial number 1. P.N. Rajeshwar. 28. Serial number 2.
My lord, in this matter, my lord, office objections is, my lord, with regard to the annexure A, is the, I have challenged the,
Move the objections, apply the objections.
no, that is, I have made the submission, my lord, because it is not required, it has to be overruled, that's.
Next day, let's give the date.
24th it may can, because urgency is there. 24th it may can. 24th, my lord.
24/7.
Much.
Serial number 3. Shri Deepak Bhaskar.
It's corrected with 69 and 70. Your lordships kindly accommodate
Just wait, we will take it up at 70.
Please, I'm ready.
Serial number 3. Serial number 4.
4, I appear for the complainant, the writ appeal is tagged along. But the contempt matters can be posted next week because they're next week.
Lords, may I request 2 weeks, please, my lords? Serial number 4, may I
31
request for 2
sir.
weeks, please, my lord? Because there is a matter
Let
pending,
I
bef-
have urgency app for the complainant.
this matter is pending before
Matter
the,
is pending in the.
Correct. If we give according to you, there will be 110. And 110 will not reach.
Next Monday.
If you leave it to us, we will be in a
Very-
position to see that it comes within
Very-
the zone.
You should have a date which is purposeful.
Very well.
Otherwise, it's everyone what is the use. Okay? You just give the date.
28.
Great.
Serial number 5. Shri Zamir Pasha.
Lords, I represent the respondent, lords, in the appeal and complainant in the country.
Give your appearance, man, we'll note it.
Please.
Please.
6/8. Serial number 6. Shri Srinivas. 7/8. Serial number 7. Shri Karthikeyan.
My lords, I beg to appear for the appellants in this matter, my lords. Lords, kindly pray for a week's accommodation, my lords. I'll comply with the office.
7/8. Serial number 8.
Grateful.
Appearing for the government, my lord. Serial number 8 appearing for the government.
9/8. Serial number 9. Shri Murugesh Charity.
My lords, for the accused, and for the accused. Writ appeal is pending. It has to be heard. Ma'am.
Yes, yes, for the matters.
Please.
11-9,
Wait for it.
serial number 10, Sri Mahesh.
For the complaint, Your Honor. 2 weeks may be granted.
16-10 to 11,
Present respondent number 1 to 6
14.
in this case. Complainant has to, my lords, include. I am respondent number 1 to 11, my lords, 1 to 6.
Which matter?
11.
Serial number 11, my lords. My lords, the complainant is party in person. She has to implead a controller of defense, principal controller of defense account by virtue of the last order, my lords. She has not done it. Let her do it, and if she does it, my lords, then notice may be ordered to principal controller of defense.
The memo with the given the account of transfer of the amount. They have disobeyed the contempt order. That's why I have filed IA for
Was to transfer the amount, ma'am.
The Navy was supposed to transfer the amount after deducting the areas of my monthly maintenance, which they have not done. So I have filed IA for reopening it and for further direction.
We'll give you a short date. Just give it.
Your Honor, I am coming from Hyderabad. I am a student. I have my exam also, and also I have a single mother. I have to drop my son to Mumbai. So
One thing, you can hear virtually. Why do you come all the way from there? You appear virtually.
I'm party person for filing the documents and other things. I have to be here. I take help from others for doing the job, sir.
This is a disposed of matter, my lords, wherein she has, my lords, filed one more application. And
We pleaded in.
not
I
it.
need some time for that, sir.
Do that. You comply with the last order.
And they also had to comply by submitting the evidence that they have transferred the monthly maintenance.
We have the documents, please.
Just give it.
Your Honor.
Till July 2020, June 2024, we have transferred the amount.
See, what was directed
From-
for the details of the amount paid month-wise to the company.
Yes, yes.
And for the indicating the period and the month. for
I
which
have
amount
the-
is-
September.
I have the list.
Just give it to us.
Yes,
September 1st to April
Copy.
31st.
And have a look first.
copies out.
Have a look first, then you can make your submissions. But you also must increase the principal, the chief controller of defense account.
I will talk to
Okay.
Please,
Just take
Your
this.
Honor.
I'll file the memo of calculation in the office today itself.
Your Honor, there is another humble submission. They have given me the medical card of me and my son, which was due since September 1st, 23. But unfortunately, I have not received the pins. It's like ATM debit card. So, and the phone number is linked with my husband's number. So I am unable, we tried using it. We are unable to use them. So may I request the honorable court to help me by
Just
adding.
take instructions on this.
But sir, we can only hand over the medical card to the dependent card and medical. Please,
Say the pin is the
Pin.
husband's number.
pin A7, respondent number 7 is appearing, my lords.
Who has given this card to her? Who has given you the card?
We have handed over the card, my lords, in the open court on the last date of hearing. And the pin will be generated, my lords, by her only, and it will be, my lords, sent to that OTP. That will be sent to the mobile number, registered mobile number.
That is
And
my
her,
husband.
she is complaining, my lords, husband is not giving the pin. We can only give the, my lords, card to her.
Is your employee?
He is retired now. He has retired.
You can still have control over him. You can tell him.
We will, my lords, communicate.
Just say
that
this.
resetting is with you, no?
31 August 2023.
You are the master of that card, no?
Please.
But you have all the
Let's-
credentials.
Now, in between the dispute of husband and wife, my lords, we are unnecessarily being dragged, my lords.
It's a
Please.
contempt case for disobeying the
One
order.
minute, ma'am. Just hold on. The counsel for the respondents has handed over
Memo of calculation.
to the
Just now, I need some time to go
the
through it.
complainant, the details of the amount paid month-wise to the complainant. This copy also states that he has also furnished the details indicating the period and months for which the amount has not been paid. That's right?
Yes, please.
Yes.
Your Honor, I have a submission to make here. I object that I have submitted a notarized affidavit in the court last month. I request the Honorable Court to kindly refer only the tabular, where I have already mentioned that from first.
1 minute, please. What we have done is we have only recorded this submission. You will look into the details. If anything is lacking, you will make your submission on the next day. Okay? Just look into it first. So the complainant who appears in person states that she shall complete the principal controller of defense accounts Prayagraj before the next date of hearing. We notify the matter on.
Your Honor, regarding the PIN and the phone number correction.
That he will take instructions.
I will.
Will take instructions.
I will, my lord, stood.
See, you will do one thing.
Yes.
Why you have also no obligation and you are the master insofar that card is concerned. You are providing the facilities. You will ensure that she avails those facilities.
Please.
Possibly impress upon the gentleman concerned, saying that if she asks for, she applies for change in PIN because that will go there.
We'll do that. We'll do that.
Next.
I may be permitted to file this memo of calculation in the registry.
So the counsel for the respondent shall also file the details which have been furnished to the complainant in the report before the next date of it.
Please.
30th August, madam. Madam, date 30th August.
Can we make it slightly early because 5 lakhs pending amount?
30th
That's the earliest we can give you, ma'am. The board is heavy, we can't really do it. Okay?
In the
Yes.
meanwhile, you can do that. Really, that you can.
So 1.5 months I got this year in the.
Should give a date.
We are giving the
After
date.
15th August,
first
some
in
date
this week.
17th.
1 minute, just hold on.
19/8, madam. 19th of August.
Thank you so much.
Next.
Serial number 12.
For the complainant in serial number 12, my lord, anytime in the second week of August.
29/8. Serial number 13, Shri Sachin BS.
My lords, I'm appealing for the
13. 30th August.
interim order make
14.
much.
14.
The respondent in the matter.
29. 15.
My lord, serial number.
I appear for the
15.
accused in this case, man.
Little urgency, my lord. The reason is there was an order of the Honorable Division Bench, my lord, by which certain action was to be taken. They didn't take action, we filed a contempt. In the contempt also, the respondents appeared and said, we will comply within a certain time frame. They didn't still comply. Next date, my lord, they came and reported that there's another writ petition filed by the same landowner who lost his title right up to Supreme Court. And the learned single judge has granted an interim order in those proceedings without making me a party, without noticing all this. So the Honorable Court has withdrawn the writ petition to the division bench. So the writ petition is also before your lordships now, my lord. Your lordship would give me a few.
We don't have English order.
1/8, sir.
Earliest, I can only request for the earliest possible date.
Of August.
Please,
Just a week away.
please, my lord, please.
If any to continue. Big matter, is it in the writ petition or is it in the
In the writ, there is an interim order.
writ petition?
Yes.
Interim order, if any to continue.
I oppose that continuation of the interim order, my lord. Please. Please. Great.
Great.
16.
Grateful, man.
16.
Serial number.
And for the accused, my lord.
59, my lords. 59 is the writ appeal. A common date, my lords, the shortest possible.
Just we'll take it up at 15, just remind us of.
Matter has to be heard.
17.
For the appellant. Going for the appellant in serial number 17.
29. 18. Shri Uday Prakash.
Appear for respondents.
30th August. 19. Shri Sitaram Rao. 19. 3/9. Serial number 20. Shri Bhaskar. 30th of September. 21. Shri Rayappa.
Lord, I prefer the appellant, my lord, may be listed after service of notice, my lord.
30th of September. 22. Shri Satish
But I
K.
appear for the counsel for the appellant, my lord. This is a case where, my lord, the respondent 1 to 26 is represented by advocate K.V. Narasimhan, my lord,
22.
who appeared, my lord, one of the respondents, and appears for the petitioner in the before the learned single judge. And government is concerned, copies are served on them, my lord.
Very well. Just give it.
R26 and 27 and 28 is the government. May I appeal to Lord to show the name of the Mr. K.V. Narasimhan for R1 to 26 and 27 28 government advocate, my lord.
Very well. Just give it.
28th
Any date may be
September.
given. I am ready.
23, Shridev, sir, 20th September.
I'm for the complaint,
23,
Mr.
Devraj,
I'm for the complaint, my lord.
Just give it 18, 26,
20th September, sir, serial number 22.
23.
23, Devraj,
Please, my lord, I am for the complaint. So your lordship may kindly have it on 6th if it is not inconvenient, my lord.
6, 8,
Oblige me.
4,
For complaint in this case, sir. I seek for, Lord, the accused, my Lord, when the day, even just before the day matter gets posted, he gives some notice calling upon certain documents, my Lord. Though we have submitted all the documents to them. And my Lord, this is the fourth notice, my Lord. For third time, we have complied all the requirements, whatever they required for passing of the bill. In spite of it, they are when the matter approaches the court of law, my Lord, they will give you one notice, and they would like to drag, my Lord. Let it be posted on 6th, my Lord. I'll
6, 8, 25, Shri Manjunath. 7, 8, 26, Shri Nishant.
Here for the complainant, may I request for 6th of August?
See.
7, 8, 27.
27, I appear for the complainant. Same order. Grateful. 7th August. I'm grateful.
27, serial number 27. 9, 8.
27, we have given 9.
9, sir, both same.
26 and 27 are similar.
26, 27. Oh. 28.
28 I am for complaint, my lord.
28,
Complainant, I am for complaint, my lord. BBMP has to file,
Pardon?
BBMP has to file objections, they are not filing. This is fourth time. Nobody is appearing, my lord.
yes, sir.
Last chance, kindly peruse the hardship, my lord.
23, 8, 29, serial number 29, Shri Hegde.
29, I appear for this case.
Short date,
29th August.
29th, little bit short date.
23rd August, sir. Serial number 29,
I appear for the complaint, my lord. For the last 30 years, the execution of sale deed is being postponed by the accused. And ultimately, this honorable court directed them to execute the sale deed for the last 11 months. They are dragging on, madam. I appear for the accused, my lord. The matter is currently being heard by the Honorable Chief Justice. If it is listed thereafter, it's fine. Madam.
14, 8,
14.
14th of August, sir.
Grateful.
Serial number 30, Shri Srikanth.
In this matter, the accused has to file objection, complaints affidavit, my lord. They are not.
11, 9, 31.
Your lordship, short date, your lordship. 11/9 is to.
What is the direction? 31 next.
31,
Complainant in this matter.
For the respondent, we have already issued the endorsement in this.
2, 9, 32, Shri Ramesh.
In this case, I am appearing for the appellant, my lord. I have served the notice to the respondent number 4, writ petition, writ appeal along with all annexures, my lord. However, the court has not issued notice to the respondent number 4.
30th August, 30th August, sir.
Oh, much obliged.
33, Shri Sagar Shastri, 33.
I appear for the complainant, your lordship. I pray for 2 weeks.
2, 9. Serial number 34.
So I appear for the impleading applicant. There's an interim order operating against me. 34, my lords, I'm for the impleading applicant. There's an interim order operating against me. I request for the earliest statements.
After the 5th of August.
8th of August.
Grateful, ma'am.
35, Shri Shivram.
In this, I appear for complaint, your lordship. That there is a direction issued, my lord.
9, 8. 36, Shri V.S. Nayak.
36 appear for the appellant.
9/8,
Your
your
lordship.
lordship. Please.
36 appear for the appellant. Your lordship. 1 week's time may be granted for the compliance.
110.
Much of.
37,
36, my lord, I'm appearing for the complainant in this case.
36, I am appear for the appellant, your lordship.
36 and the first list.
36.
36 for BS Manjunath, I'm appearing for it.
36 in the second
110.
list, your lord.
Just 1 minute, ma'am. We are
Second list, sir.
Just hold on.
36 in second list, madam.
Yes, your lordship, I am appearing in the second list. BS Nayak.
BS Manjunath for BS.
Yes, sir, 36.
110.
110, madam.
Earliest date in
Let's see.
blood. Representation has been not considered. They have not considered the representation. It's an ex-serviceman.
36 is writ appeal.
Sorry.
You have to take steps.
Is it your matter?
Like mine is a contempt matter. Little bit confused.
37. Virupakshaya. 27/8. 38. Shri KK.
Lord, in this, the respondent is, accused number 1 is served, no representation. My lord, this is 82 years old, the complaint is 82 years old.
18.
Right.
39. Shri Azarmir. I appear for the complaint, my lords.
I undertake to file wakalat on behalf of the accused, my lords.
A short date may be given, my lords.
Sir, appears for the respondent states that respondent accused states that filed within 2 days. When will you file wakalat?
Wakalat during the course of the day, my lords.
For the objections,
My lords, 2 weeks.
2 weeks are granted to file compliance affidavit.
13. 13/8.
My lords, if it can be after the 15th of August.
15th of August, after 15th.
After 15th, any date.
21/8, sir.
Grateful, my lords.
Grateful. Serial number 40. Appearing for
Urgency.
respondent.
My sugar factory has been shut, my lords. I have to seek for 12th, it was listed, it didn't reach. My lords, earliest date, 12th, 700.
13/8.
My lords, that's too long, my lords. 700 workers I'm paying salary. No, my lords, this month, if your lordships can kindly, 12th it was listed, it didn't reach. I know, my lords, I bow down, my lords. My lords, first week at least your lordship can kindly consider.
Senior is not available. It may be taken on 3rd week of August.
My lord, that's too much to my lords, that, my lord, they have been taking time.
First week of August. Sir, 5/8, sir.
Great.
Next.
41.
I represent this case.
Service. 110. 42.
I appear for the appellant in the matter.
11/9. 40. 43.
Appear for appellant, my lord.
Respondent, my lord. Lordship, it may be second week of August in it.
19/8. 44. Govindraj.
Delay of 9 days is there. Because the runner just passed the order directing the appellant to approach the civil court. He already filed OS 129 minority. That delay may kindly be carved.
23/8. 45.
45 for respondents. This is a matter pertaining to Twitter blocking orders passed by the Meiti minutes. Learner single judge has dismissed the writ petition with the cost of 50 lakhs.
I'm for the appellant, my lord. In this matter, we filed an IA seeking production of certain documents. Rejoinder has been filed, the pleadings are complete. Matters to be heard on the IA, my lord.
25/9.
Lordships, could it be a 19/8 minutes? This learned ASG appears in the matter. A request 19th August minutes. I will place
We have also an option. Just give it.
this.
We'll have it in September.
25/9, sir.
Obliged.
Much obliged.
25/9. 46. Shri
I am
Krika.
for the petitioner in this matter, lordship. Some urgency is there. Kindly have it on Wednesday, my lord. Your lordship, in the medical admission is going on. Counseling is started, my lord. That's the reason. Wednesday, my lord.
25, sir. 25/7.
Much obliged.
47.
For the appellant, my lord. My lord, this appeal arises out of the very same impugned order as in serial number 7 of list 1, my lord. Serial number 7, my lord. Both the matters may kindly be connected. Please, my lord.
Connected.
Both are common order, my lord.
They arise out of the very same
To make a request.
They have made the application before the registrar, I think.
We will just re-notify. Re-notify.
My lord, a memo had been moved before the registrar, my lord, but the matters have not been connected.
We'll give you a short date.
Please, my lord.
Just give a short date in 37 before court. You make a request there so that.
My lord, the matter was listed on 18/7 before Court Hall 1. The Honorable Chief Justice directed us to move a memo before the registrar, which has been done, my lord. However, the matters have not been connected.
See that memo. See that memo.
Please.
Go to the register so that both can be tagged. Just give it a short.
Short date, maybe.
2/8.
My lord, the first list 7 matter also common, my lord, common order,
Yes, is it a common order?
common order.
Please, my lord.
We'll adjourn that matter to a date beyond 2nd August so that you can get an order in the memo. Getting the point?
Please, my lord.
Both can be taken up.
Please, my lord.
48.
For the appellant.
Great.
In this case, well, 2 weeks back, I moved the matter first.
Madam,
Whenever the matter is called, just appear that this one.
this one 7 here to appear.
Please, my lord.
48.
For the appellant, 2 weeks back, I moved the matter first. It's an urgency. Well, Specifically, date was fixed to today, my lord.
6.
We give you after 2 weeks.
My lord,
Bond after 2 weeks.
No, my lord, there is an urgency. Within a week.
My lord,
it will be fixed, well.
6/8.
one more appeal is filed by the KDB on the same order. That appeal may be connected with this.
This appeal, 1005 up to.
Writ appeal number 1 double,
File a memo.
please. I shall do.
File a memo.
I shall.
Please. And also I'll serve the copy of the 2 to 4, my lord. Show the name of the BB Patil on behalf of the KADB, my lord.
Sir, who appears, Mr. Patil?
The BB
I
Patil.
appear on behalf of party.
2 to 4, my lord.
We will file it.
49.
49.
Appearing for petitioners, my lord.
31st, my lord. There is an
Petitioners.
31st of July.
6/8, sir.
6/8. Early date, my lord. There is an urgency.
31/7, sir.
31, sir.
49.
Appearing for petitioners.
I appear for the respondent state.
I am appearing for the respondent number 4 in this matter, my lord.
Yes.
After 3 weeks, my lord, may
19/9.
much.
Serial number 50, government advocate.
I appear for the petitioner.
13/9. 51. Srimati Lakshmi Holla.
May please, your lordships. This is a matter filed in public interest, my lord, pointing out that the children on the streets, my lord, are deprived of education, my lord. Then, my lord, when the matter was before this honorable court, it was regular bench. Please, lord. And a date may be given.
29/7.
Can it be 31st, my lord? 29, I am not in.
31/7, 31/7, sir.
Please, lord.
52.
I'm appearing for respondent number 6/8.
Reporting complaints ಅಂದ್ರೆ case close ಆಗ್ಬಿಡುತ್ತೆ.
52. My lord, in 52, in the contempt proceedings, I am for the complainant. This matter pertains to the land acquisition. Shortest date why I am requesting is matter pertains to land acquisition by KADB. I am the owner. The trial court and appellate court and this honorable court declared me as owner. Meanwhile, by fraudulent act, the authorities have released the entire amount to third party. That's the biggest fraud. Where I am requesting 96 acquisition, I did not get even a single pie, and being a.
14/8, sir. 14th August, sir. 43, 14%, Shri Gauri Shankar.
My lord, appearing for the government in this matter. This is with regard to the challenge to the Sakala services, the act amended in 2014, my lord. This matter needs to be heard. Pleadings are complete.
29, madam. Madam, 29.
Please, much
54.
obliged.
Serial number 54, parties are willing to appear before Lok Adalat. There is element of settlement.
Appear for the respondent, top date, blanket is there. Be notified.
29/7, sir.
Give it before that.
25/7, sir. 55, Shri Murthy DL. 55. 14/8. 56, Shri Bhimaya.
I am appearing for the appellant in this case, my lords.
I am for the
Interim order may be extended, my lord. I am for the appellant, my lords. Interim order may be extended.
We have done that.
22/8, sir.
Interim order may be extended.
Sir, ಮಾಡಿದ್ದಾರೆ,
Your,
sir.
your
Okay.
We have
lordship,
done that. We have done that.
your
Much,
lordship,
much, much.
your lordship, any date after 23rd August, your lordship.
Just give it.
29th of August, madam.
Much obliged.
Much, much, much.
57.
57, I beg to appear for the appellant. Lords. Some date during the first week, Lords, if it is possible.
Any urgency there, Miss?
Lords, there is urgency.
What is that?
Lords, we are the purchasers, the registration of the document has been challenged here, pursuant to which, my lord, the single judge has allowed the writ petition. And Lords, I have questioned the order passed by the learned single judge. And in view of the cancellation of my registration, Lords, the respondents are, Lords, putting up constructions in the property, Lords.
Give a date somewhere in August.
Sir, 20th August, sir.
Any first week, sometime, first or second,
Yes, see, there. You have to take a chance.
first or second week, before 10th, Lords.
Give us second week.
8th of August, sir.
Next, I'm obliged.
58, Shri Akash.
Appear for appellant in this case. But in this matter, the issue is regarding the seniority of the post. May I request for this Wednesday, my
Notified.
lords. The term of the post is coming to end, my lords, in the next week.
Why it is coming to an end?
My lords, the term, my lords, was fixed, my lords. It's a fixed
Is it
term.
tenural appointment?
Please, my lords.
When is it coming? Whose appointment?
It's of the professor, my lords, post of a professor.
I know who has been appointed.
My lords, no, there is no appointment. I have challenged that appointment, my lords. It is coming to an end on this next week.
Of the third party?
Please, my
That will inure to your benefit.
lords, I request for a Wednesday, my lords.
Why? When you tell us the urgency.
My lords, it's my colleague's matter.
Like this, the tenure is going to come to an end, that will inure to your benefit. You have challenged the
Please.
appointment? How is that? Give a date normal.
29,
Great.
59,
Lords, this matter may kindly be taken up along with 16, my lords. Same order.
Along with
Serial number 16, my lords, which my lords-
60, 60.
16, my lords, which my lords passed.
Just do give the date, the common date in both the matters.
16. 27/8, sir. 27/8. 27/8.
Next.
Serial number 60, government advocate.
Re-notify.
16.
61, re-notify.
30th August. 61, Nagarajappa. 2962, Sampath Anand Shetty. 3963, Shri Badri Vishal.
Re-rate, my lords.
21/8,
With
64, Shri Ajit
Respond.
Shetty.
64, I beg to appear for the petition. There is some urgency.
19/9, 65.
This case, my lord, I am appearing for petitioner. Lord, here, the query lease has been granted in the particular survey number 128. Subsequent to that, Deputy Commissioner, my lord, has granted for the first week of, my lord, August.
20th of September.
No, my lord. Since, my lord, the query lease has been granted.
second week of August.
13th August. 66, Sri Krishna Vyas.
Lord, I appear for the counsel for the appellant, my lord.
Date given matter, Lordship may kindly have it next week because I have filed a vacating stay application. The
13.
reason.
No,
Next week, any
66.
date.
66, he will.
66, my lords.
66, sir.
66. Interim order is in operation.
Interim order may be continued.
49,
Date.
67.
No, my lord,
Yeah, for the
some urgency is there, my lord. That's 66, my lord, 66. Next. My lord, we have filed a vacating stay application. There is a stay, there is a first week, any date.
57, 8.
67, my lord, there's some urgency.
My lord,
Around
67, I appear for the appellants, my lord.
the respondent, my lord.
Yes, 67.
Any shorter date, my lord, since the urgency is that 14 employees who retired in the year 2013 have been denied some leave encashment, my lord. 2013 case, so 2 have died, my lord. Two have passed away, my lord. They're 70 in their 70s. Any August date, my lord.
29, 8.
Obliged.
Obliged, my lord.
My lord, with request, my lord, 66, some date may be in first week of August.
27.
Otherly, development work has been stopped, my lord. That is the reason.
Call the council, where is the council?
Yeah, I will inform him, my lord.
No, yes.
Yeah, please.
Yes. Then make it.
68, Sri Deshpande, Amit Anand. 49, 69, Sri Deepak Bhaskar.
69, 70 as well as item 3. Which matters, you said 69? 70 and item 3 all arise out of the same order. It's a common order. My lord, we are pressing for some interim relief as a threat of dispossession. Would your lordships consider 31st of this month or 1st August? Lord, what has happened is that I had a sale deed from BDA, but now because of no fault of mine, that is being ignored, and they're saying we'll give you site in some other 1st August if it's possible.
2, 8, sir.
2, great,
All the matters, 3 matters.
great.
1, Sri Mukanappa. 21, 8. 72. Sri Chandrasekhar.
Notice may be ordered in this case, my lord. It's for fresh matter, contempt petition. Notice may be ordered.
1, 8, sir. 73, Sri Gopal. Notice. 73.
This case, my lord. My lord, it's a covered by judgment. And also, my lord, I heard that they have filed a contempt, my lord. Hence, my lord, it's,
You're referring to 73.
yes, madam, 70.
8th of August, 74.
There for appellant,
14, 8.
appellant. The notice has been served other side, but did not appear.
7,
It is down for preliminary hearing.
70. 14, 8, sir. 14, 8. 75.
Appear for the petitioner,
Yeah,
madam.
yeah, for the respondents.
Lord, have to file rejoinder, my lord.
13, 9, sir.
This interim order may be extended, madam.
Which matter?
In 75.
75 is an interim.
Yes,
order.
ma'am.
Interim order if you need to continue.
76.
I appear for the petitioner, my lords. My lords may kindly recollect, my lords, from last week, my lords, this matter is posted to today. This is pertaining to, my lords, the continuation of the judicial member of the KSAT. Lords, there is some urgency, my lords.
Statement of objections have been filed. My lord may have this next.
Wednesday, my lords. Lords,
31.
Wednesday, my lords.
31, 7.
Very well.
77.
Appear for the third respondent.
Hearing for the government, my lord.
Association of People is the authority of civic community side by BDA. When the cost of the land has been paid and BDA has to execute the sale deed, someone set up to the extent that it's a corporation property. A vacant land is lying for the last so many years and not to the benefit of the members of the, any earliest possible date it can.
23, 8, sir.
Earliest, my lord.
23rd of August.
Petitioner form may be shown as a petitioner in the first matter. First matter, WP 11325 of 2018. Therefore, Mr. Krishna appears for
For petitioners.
Follow
So Sheikh Ismail's
Lord, that name may be deleted.
wakalat file.
Yes, ma'am.
Many of the petitioners have either died or not
Mustafa
available.
has filed wakalat.
No,
This paper was-
23rd August,
Please.
78. Kulkarni.
I beg to appear for appellant, my lords. My lords, that the writ appeal is of the roster bench is this code. As far as that criminal that CCC is roster bench is first code. I moved there also before the CJ, and it is listed on 24th as far as CCC is concerned. Only withdrawal is there, my lords, in both the cases.
Yes, we'll give you.
For the respondent and accused in 70.
Sir, you want to withdraw this appeal, sir?
Yes, my lords, both writ appeal as well as CCC.
Sir, 29/7.
Yes, my lords.
79.
I prefer the appellate, my lord. Hearing for us.
29. Serial number
Date may be given, my lord.
80.
My application for vacating also to be considered, my lord.
In September only.
29. Serial number 80.
Make one submission. My lord, one matter, serial number 13, your lordship, adjourn this matter for 30th of August. There's some difficult because the problem is, your lordship, because they lost their land in the year 1971, but till today they have not been compensated. Finally, your lordship, government decided, please,
Serial number 80, 39.
my lord, serial number 13, 13, my lord. 30th of August. Respond.
Who was there on your behalf when the matter was, you all there, you're appealing for the other party?
Respondent. I am for the appellant.
Therefore, they are the appellants, my lord, my lord, your lordship, because after the disposal of the writ petition, please.
The councils who are appearing in these matters?
Yes, ma'am.
Can change the date? Just change the date.
First week of August, may I request, my lord, because first week of August. Please.
98, madam.
Please.
You have to see the board.
Yes, I understand, my lord.
9th of August. madam.
Great.
10th matter, it will not reach.
9th of August.
Yes.
If you go according to your request, it will be 110th matter, it will not reach.
Right.
If you agree for our day, it will be lesser, it may reach.
I
Choice
take
is
chance, my lord.
Then you may get a further date. Of the second
I'll,
September.
my lord, I'll take a chance. Grateful, my lord. Grateful, my lord.
Chance.
Please. Grateful.
Serial number 66, I have informed the other side council, madam. He has gone to civil court. He told me to get some early date, madam. First week or any date.
27.
66.
Yes, madam. First weekend,
7, 8, sir.
please.
Sorry. Serial number 16 and 59, my lords, are given 27.
Which date we have given?
27/8.
What can we move short of?
69, sir.
It's
Serial
next
number-
month end.
Sir, serial number.
We have no issue. Who was the other side?
I'll inform, I've already.
That's the only difficulty, you know, when the council say he would be under the impression.
27, 8.
No, I'll inform them. I'm sorry.
No, but then you call him.
I'll inform him.
Please don't take it otherwise, just call him. Better would be that. Okay, just call him and change the date. We have no issue.
Yes.
Serial list number 1. Serial number 1. SV but
For the appellant, my lord, that there are two office objections
Insofar as first objection is concerned, during the course of the day, I will comply with. The second objection, my lord, is concerned, my lord, I have filed memo of appearance in respect of appellants 8 and 9. That may be accepted, my lord. Number is required to be changed. I will change it today. Insofar as 8 and 9 is concerned, my lord, memo of appearance is filed.
Objections. What are the other objections?
All other office objections have been complied, my lord. There are only 2 office objections which are left out, which is newly found out by the office, my lord. One is that, my lord, there is mistake in the number.
So why don't you remove those?
I will be removing it. First objection, I will be removing it today itself. The second objection is my lord, I have filed memo of appearance for respondent number 8 and 9. I have appeared for them in the writ petition also. That may
Very
be
well.
accepted. Only one objection, my lord, I will remove it today itself.
Okay.
Because of the day.
The counsel for the appellant submits that insofar as the objection in respect of correctly mentioning the writ number in the writ appeal prayer, the same shall be carried out during the course of the day. Insofar as objection number 2, that the signatures of appellants 8 and 9 are not forthcoming on wakalat is concerned. Have you removed this?
No, insofar as that is concerned, my lord, I have filed memo of appearance that is permitted under the rules, my lord. I have filed the memo of appearance that may be accepted, or else I will have to make them as respondent only.
But you have to file wakalat, na?
For the writ appeal, my lord, memo of appearance is accepted, my lord.
For when?
My lord, it's quite some time back, my lord, it is applied, it is allowed, my lord. Or else I will have to make them as respondent if they don't come. It is writ appeal is considered intra-court appeal, continuation of the.
See, what is the difficulty to file a wakalat?
Grant me a week's time, my lord, within that I will.
Yeah, states that the wakalat shall be filed on behalf of respondent number 8 and 9 during the course of the day.
No, that I may, they will have to
Within
come
1
from
week.
village, my
Yeah,
lord.
within 2
Week's
weeks.
time.
Re-notify on.
Much obliged.
14.8. Sir, 14.8. Serial number 2.
In this case, I may permit you to withdraw, my lord. With
Want to
liberty,
withdraw
my
it?
lord. Withdraw the appeals with liberty, my lord, because they have given the licenses now.
So you will withdraw it simpliciter.
My lord, otherwise I won't, because now they've renewed the licenses. I have to apply again. Only with liberty to approach the
So
authorities.
that liberty is always there, ma'am.
Yes.
It's a fresh cause of action.
Yes, my lord.
The learned senior counsel appearing for all the appellants.
Yes, sir. On behalf of the appellants.
For all the appellants?
Yes, yes, my lord.
For the appellant states that she has instructions to withdraw the writ appeal. The appeal is dismissed as withdrawn. In view of the dismissal of the writ appeal as withdrawn, comma, the IAS have become infructuous.
Serial number 3. Venkatram Reddy.
Yes, madam. This case. This
Yes, this is something.
appeal, please.
Yeah, yeah. To be seen. Just show us the-
This matter was dismissed on 19/7/2001.
21.
That I have returned file to the appellant. Kindly issue notice to the appellant.
Madam,
minutes. If so, court notice may be ordered. ಅದೇ ಈ ಚೀಟಿ ಸಿಗ್ತಿದ್ರಲ್ಲ.
Here for whom?
I am appearing for the LRs of respondent, deceased LRs of respondent, number 1 minutes. So, while the matter was abating, we are not under the such knowledge about the.
Here for Srimati Bhatyamma, Sundara and Rahuti.
Yes, minutes. They are all LRs of deceased R1 minutes.
Was brought on record on the last day,
Yes, minutes.
2nd July.
Yes, minutes. So that I filed an up.
And abatement application is pending.
Yes, minute. Yes, minute.
Order on that setting aside is set aside, the abatement is set aside, then the original order of dismissing the appeal gets revived. That need to be looked into.
So there, yes. thing is, they were not clearing all the financial benefits in favor of these LRs. By saying that the appeal is abated, the matter is closed, you are not entitled for that since your ancestor is deceased and all that what they are saying, my lord. Actually, that abatement is in our favor, my lord. Since it is abatement, that order of the learned single judge would be prevails, my lord. So that order of the learned single judge would be prevails and come into operation. So that what they are saying by the appellant entity is you are not entitled, it is abated. They are taking their advantage in their favor. That's why.
For the learned single judge.
Yes, madam, as well as Central Labor Tribunal also. Actually, it is in our favor.
If we set aside the abatement, then we'll have to hear the appeal on merits.
Certainly, madam. Kindly hear the matter on merits. Even it's also already it's covered by judgment by this honorable division bench. And some other laborers have approached in the similar circumstances.
Even single IA is not served on me. All the IAs filed by me also is not served on me.
They'll give the IA.
All the previous dates he has not appeared more than 6-7 hearing dates, madam. Since I am not is able to serve the copies also.
Cited IA 1 of 2023.
Yes, madam.
By the 23, the IA 1 of 23 was filed by the counsel for the last for the respondent number 1.
Yes.
With the prayer to bring the LRs of the respondent number 1 on record. It was filed with a prayer, just say with prayers to condone the delay of 2, 3, 4 days in filing the application, to bring the LRs of respondent number 1 on record. And to set aside the abatement order dated 19/7/2015. We, while passing the order on 2/7/24, go have though we have noted the aforesaid fact that the application is also for setting aside the abatement order dated 19/7/2021. No order in that regard has been passed. Since we have allowed the application, we clarify that we set aside the abatement order dated 19/7/2021. At this stage, when a counsel appearing for the appellants would submit that after the dismissal of the appeal on
19/7.
Yeah, after the appeal was after the order dated 19/7/2021 was passed, he has returned the file of the appeal to the appellants. So he states that a notice be issued to the appellants for their appearance on the next date of hearing. The court notice be issued
Please.
to the appellants, returnable on the date fixed.
This is better for issuance of court notice, madam. Instead of on my behalf. Please.
27/8, sir. Serial number 4. Shri Abhinay.
The appellant, madam.
Yes.
Acceptance of paper publication. Acceptance of court notice through paper publication.
Yes, sir.
Going to be order dated 5/6/2024. About the this to respondent number 1 has been effected to publication. Express the newspaper Bangalore edition. 2024. We find there is no in view of the which of this the paper cutting of the publication has been filed on record. The way of an
On 21st of June 24, madam.
so there is no evidence for respondent number 1. Say despite service to publication, there is no appearance for respondent number 1. What has to be done?
And the matter, my lord, has been admitted.
With this the appeal for hearing on. So date counsel for the parties are able to file the written submissions. Along with the judgment, they have to rely.
Connected matter, my lord.
4.1, appeal,
4.1 has to be.
state appeals, your lordship. I have filed 2 applications, one for
That's right.
condonation of delay in filing the recalling the application. IA number 2 is for recalling the order 4/11/2022.
69/22 it was dismissed.
For not taking
Please.
steps.
I mean, 1/22, 2/22, these two applications are seeking continuation of delay in the recording application and the recording application itself for the reasons stated in the affidavit, company affidavits accompanying the application from the delay of how much is the delay?
Mention on the-
They have cleared the days. I think the recording application is condoned. Please recall. Before the applications are disclosed.
411, 69.
This in 4.1, my lord, service is not complete. In 4.1, service is not complete. They'll have to take steps to
That notice be issued. to the-
sole respondent. Sole respondent there.
Who is all respond?
Their sole respondent.
Can I go there?
Great.
1410. Serial number 5.
Appear for the complaint. For the complaint, my lords. Milords supposed to file it today, my lords. And the author is, accused is not present, my lords. The last date of hearing, my lords, he had fallen down and he was being taken to the hospital.
How is he now?
We have no information about that, my lord. We are just admitted to the boarding hospital. Thereafter, my lords, no information.
Find it's noted that the accused is not present in the court today. Available warrants.
Please.
Issued for a sum of rupees 50,000 to be executed by the concerned police for during the appearance of the accused before the court on the next date of the
Please.
case. For the preliminaries. Court government leader shall file the examination in chief of the witness.
Please, my lords.
Before the next date of the.
Please.
13-8. Serial number 6.
Short formula, short accommodation. There is a 9 days delay in filing, my lord. It was noticed only, my lord. 6.
Serial number 6, W 20 of.
I'm sorry.
20 of 19.
2019. No, there is a delay of 178 days in filing the appeal. List. Para 3 of the affidavit made have stated reason for.
You appear for the appellant?
Yes, my lord, appellant.
What do you say on merit?
The merit, my lord, the site was allotted in favor of the appellant in the year 2005, 1995. So as per the rules, my lord, if the allottee belongs to scheduled caste and scheduled tribe, so he has to deposit the amount within 3 years from the date of communication of the allotment letter. So the allotment came to be cancelled within 1 year from the date of allotment. In the year 1996, the allotment was. That did.
Tell us one thing, did you make the payment within 3 years?
Yes, blood, within 3 years, but before that, they have cancelled the site.
Did you say so?
Yes, I have stated, Milad. I've stated. In the writ petition itself, Milad, I have stated. Rule, para 4, Milad, the rule.
Yes, ma'am.
And then this matter is, your lordship may, please.
Yes, ma'am.
But in identical cases, well, this court has allowed. And the appeal is pending before the SLP is pending before the Supreme Court. The same. Please, they held that, Malad, they are also entitled. No, Malad, next week, I will produce the dog. Yeah, no, the division bench has. Malad, yes, he is also aware of the order.
In 1995 or there.
Please.
Was the amendment brought in?
The 96. Dan Malad, your lordship may kindly see, the amendment was brought in the year
2005.
2005. Yes.
How can it relate back?
No. Your lordship, Dan Malad, the court, the BDA has issued two notifications, the circulars, to accept the amount with 21% interest. The two circular was issued in the year 2007 and 2010. On the basis of 2010, on the basis of that, Malad, I have made a representations. So that.
That circular says.
Yes.
1/1/2000 onwards, whichever the allotment is made, that may be done.
Yes.
It doesn't say 1995.
But the court has held that, Malad, even they are also entitled. That judgment, Malad, I will. So, no, next week, Malad, have this on next week. And tomorrow. Tomorrow, you will have this on tomorrow, Malad. Tomorrow.
57. Serial number 7. This one.
Malad, the same order, common order was challenged in the serial number.
We will have it after second. By the time get it clubbed, then we notify them after 2nd August. So 10th on.
12th of August.
12th August.
Yeah.
Yes.
Only thing, last time I made a request to my Lord's Mayor, where the subsequent purchaser has stepped in, after the writ was allowed, they re-auctioned the property and there is a subsequent buyer. Can I make that request, my Lord, that?
We are only saying this, it appears there is a connected appeal also which was listed in.
That is by the subsequent purchaser.
But they are seeking clubbing of this order, no? That writ appeal also. So let that order be there, both will come together.
Yes, ma'am. In the meantime, my Lord, what I would request is let the parties maintain status quo, so that the site will be held intact. Because the BDA.
We are having on 12th August.
Yes, ma'am, I understand, ma'am. He has already precipitated the matter by digging a borewell and all that. Last time I made a submission to your lordships, my Lord.
Can we add much before that?
Please, my lord, a shorter date maybe.
With the 5th August.
5th August.
Grateful.
Grateful. Serial number 8, reporting settlement.
But appear for the appellant. There is one issue insofar as one of the item is concerned, my lord, between the family members. Lordship may have after 2 weeks, my lord, will report the settlement.
You are still exploring it?
Please. Yes, my lord.
Other chances getting settled?
My lord, one item. Please, my lord, one item.
The list of counsel for the parties. We notify them.
14th August.
13th August.
Please.
Hearing.
Great.
Serial number 9.
Appealing for state, my lord. In this matter, respondent number 2 is passed away. I'll take necessary steps regarding LRs of respondent number 2, my lord. Ratnamma. She is the only respondent. She is no more now. R1 is deleted. Venkatramu. His wife Ratnamma has also passed away. We'll take steps against. She's having 3 children, 4 children, my lord. We'll take steps.
Has expired.
Ratnamma, my lord. Yes, my lord. Yes, my lord. She was appearing by an advocate. Yes, my lord.
Expired. Since to file an application, bringing request.
Chapter 21.8,
21.
serial number 10, Nero.
I appear for the appellant. Now that your lordships have heard both of us on law, my lord, it is my respectful submission that what emerges are as follows. I'll state what I understand to be the legal position, my lord, and then I will point out the fallacy in the approach of the respondent. First, my lord, if in fact there is a closure, the question of any industrial dispute arising therefrom does not arise, excepting with respect to non-compliance with the provisions of compensation as provided under the Industrial Disputes Act. That is proposition number 1, my lord. I don't think, my lord, on all these propositions that I'm going to place for your lordship's consideration, there is any divergence between my learned friend and myself. Second proposition, my lord, is that the justification or the legality of a closure cannot be subject matter of an industrial dispute. All that can be considered to be an industrial dispute is whether there is a de facto closure. Third proposition, my lord, is if there are more than one units, then, my lord, the question of functional integrality becomes relevant. Whether employees or workmen in one unit can be provided employment in another unit will arise in a situation where there is functional integrality. That can become a subject matter of an industrial dispute. Existence or otherwise of functional integrality as a ground for providing employment instead of retrenchment can be a ground for a reference under section 10. No difficulty, my lord. Point number 4, my lord. Even if an order of reference is an administrative act, still the government is required under law to apply its mind as to whether in fact there exists an industrial dispute or not. Government, my lord, in other words, is not a mere post office. That's proposition number 4, my lord. Proposition number 5, my lord. A complaint under section 25O cannot lie at the same time contending that there is no closure. And I'll elaborate this last point, my lord, and I believe, my lord, that this last point will clinch the issue in my favor. If there is a complaint of violation of 25O, and the same breath it cannot be said that in de facto there is no closure. The non-compliance with the provisions of 25O presupposes de facto closure. The grievance is that you have not complied with 25O. These, my lord, are the propositions.
On all these issues, my lord, as I indicated a while ago, I do not believe, my lord, that we are at variance on the legal position. The question, my lord, in the instant case is whether on facts, there is even a dispute that the unit has not been actually closed.
They allege the violation of 25.
My lord, they allege a violation because they file a complaint before the chief secretary saying, please permit me. Yes, I have now filed it before your lordships. They, my lord, sought permission of the government to prosecute me. My lord, I ask myself, if there is a application filed before the government saying, please prosecute the management because they have violated 25O, in the same breath, can they be heard to say that in fact there is no closure? That clinches the issue in my favor. Now, my lord, please be kind enough to look at the scheme of the act. If your lordships are kind enough, my lord, please see 25O. And this aspect, my lord, has been, if I may say so with all the humility at my command, has been lucidly explained by a division bench judgment of the Jharkhand High Court. I will place that for your lordship's kind consideration. My lord, if your lordship will kindly see 25O for a minute, my lord. An employer who intends to close down an undertaking of an industrial establishment to which this chapter applies shall, in the prescribed manner, apply for permission at least 90 days before the date on which the intended closure is to become effective to the appropriate government, stating clearly the reasons for the intended closure of the undertaking, and a copy of such application shall also be served simultaneously on the representatives of the workmen in the prescribed manner. I paused for a moment here to point out your lordships, my lord. 25O applies in a situation where chapter 5B applies. Because 25O, my lord, is in chapter 5B, and the opening words of the section itself is an employer who intends to close down an undertaking of industrial establishment to which this chapter applies. Now your lordship may kindly go to 25K. To whom does chapter 5B apply? That is answered, my lord, in 25K. The provisions of this chapter shall apply to an industrial establishment, not being an establishment of a seasonal character or in which work is performed only intermittently, we are not concerned with, in which not less than 100 workmen were employed. So, my lord, the allegation of the union before the government was that here is a industrial establishment which comes within the purview of section 25O, because I want you to add the number of workmen employed in Tumkur and the number of workmen who are employed in Bangalore. And if that addition is made, it increases 100. They have not followed the provisions of 25O. In spite of it, they have closed down the Tumkur unit. Therefore, please prosecute. Give me permission to prosecute. So, my lord, two issues arose. Or one, whether Tumkur unit and Bangalore unit can be considered to be one unit, and therefore add the number, and therefore it becomes more than 100. The second, my lord, is whether in fact the provisions of 25 are applicable.
Mr. Raghavan, that's their case.
That's their case.
There is an interchangeability between.
Yes, that was negatived. Negatived by the chief secretary passing an order on 25O.
But we are only on this. What is being urged now is once the factum of closure has been admitted in 25, complaint under 25O has been filed. Their case is insofar as the closure is concerned for which reference has been made on interchangeability. You have closed Bangalore or Tumkur, whichever, then we should be accommodated elsewhere or the other one. That's their case.
That's a case before your lordships in the submissions. In fact, that is not their case. Not one whisper even in the petition that they filed before the conciliation officer. Well, that representation doesn't talk about exactly, Manoj, that's what I'm that representation does not say there is functional integrality between Tumkur and Bangalore and therefore give me employment in Bangalore. That is not their case. Not one whisper about it. If your lordship will kindly see, Manoj, the functional integrality. Where is my notes?
Is in the
Okay. Lord, if your lordship will kindly look at their representation, my lord, which your lordship will.
That's the case set up before the level single judge.
Exactly, without basis. That's exactly my grievance.
No. But the case set up, who will determine?
But it should be a case set up before the government, not before the court.
Who?
Before the government. Before, in the petition that was filed before the government seeking an order of reference or conciliation proceedings, failing which reference to the court, they should have set up this case, not.
Thing is, Mr. Arvind, the reference has been made. Now the reference would be considered by the court.
But the reference does not relate to this aspect at all. The reference does.
Not this time. What are the terms of reference?
Well, the reference that has been made to the industrial tribunal has nothing to do with Bangalore and Tumkur and functional integrality. And the law, my lord, is also very.
No, are we that? Is this the stage or it should be the stage before the labor?
No, my lord, it should be because the labor court's jurisdiction is confined to the order of reference. It's not in a civil court.
Merit. On the merit, who will decide? Now, can we decide?
My lord, if there is a reference, your lordship will not define. If there is no reference, this labor court also cannot define. You cannot decide.
Can look into the representation which led to the reference.
Most certainly, please look. That's exactly what I'm saying. In the representation which led to the reference, not a whisper about functional integrality.
My lord, that I'll show my lordship. That is precisely there. And I've accepted the provisions in my synopsis. I'll point out to that aspect now.
Yes, if the representation, whatever it's worth.
Yes.
Whatever it's worth, if there is a representation saying that there is a functional similarity between Tumkur and Bangalore.
Please.
If Bangalore has been closed, we should have been accommodated in the Tumkur.
It can be a dispute. Yes, but I'm not saying no. The question is there one?
Let's see that.
Now, please look at, my lord, the representation that has been made. If your lordship will kindly look at, my lord, the representation that has been made. Page number, page number. Kindly turn to page number. Give me the page number. Kindly turn to page number 246. The representation dated 8th of June 2016 before the Assistant Labour Commissioner. My lord, if your lordship will kindly turn to page 250 at paragraph number 12. It obviously cannot be, my lord, because they went before the chief secretary and then said, please prosecute them for violating 25O. Yes, my lord. Factually, yes, my lord. I bow down to what your lordship. Now, may I read this, my lord, if your lordships are kind enough to permit me to do that? Later, the management went on accusing the workmen on purported reasons and also with a malafide intention has schemed to harass the workmen by fostering false allegations by various ways. The management all of a sudden on 6/6/2016 from first shift did not allow the workmen inside the establishment and also displayed notice dated 6/6/2016 stating that due to purported prolonged labor unrest resulting in allegedly loss of productivity thereby impacting the supposed profitability of the unit, running the Tumkur unit rendering superficially financially unviable. Hence, they have decided to close down the Tumkur unit permanently. This action of the management is highly deplorable and also a clear case of unfair labor practice and victimization policy. Management has given so-called settlement and alleged compensation. That the illegal closure, your lordship, I mark that, my lord. The complaint is that of the establishment under the guise of alleged prolonged labor rest resulting in purportedly loss of productivity, thereby impacting the supposed profitability of the unit, running the Tumkur unit into losses, are illegal, unjustified, being malafide. Let me assume everything, my lord. The said action of the management is a clear violation of section 25O of the Industrial Dispute Act. The action of the management is also in violation of 25G and 25F of the ID Act, that the management is running its show in full swing by way of producing, connecting flange, etc., in one or the other fashion. Hence, the management is debarred from closing their establishment at Tumkur on the aforesaid reasons. Assuming that I have a parallel unit running in Bangalore, which manufactures the same, the question is not whether I have two units manufacturing the same. The question is whether there's functional integrality. One must die if the other dies. That is the principle.
Mentioned in para 14, my lord.
Well, let me, if you don't mind. But I appreciate my young friends. No problem. I appreciate, my lord. In fact, in the written submission, she is. Yes, my
Exactly,
lord, I will read it. I will read. I will read that, my lord. The management is at all wants to close the establishment. They have at first instance has to obtain prior permission from the government as per 25O of the ID Act, since all the units of the company constitutes one establishment. That's all right, my lord. Maybe one. Now that has been negative. In any event, that has been negative now. Today that order has become final. The 25O order, I produced it before your lordships. They made a complaint that it is one establishment. The government said, no, it is not one establishment. Yes, yes, I have produced it. Your lordship may look at, my lord, the order passed by the government. No, in fact, my lord, the correct, if I may say so. My lord, in a situation where they dispute this order, then 25O itself provides that that itself can be an order of reference. So therefore, it can't be a reference in this. It has to be a reference on the basis of the 25O order.
Yes, 25O.
But it admits the factum of closure. Otherwise, there can't be 25O violation.
25O, what do they say 25O?
Well, that you have done it without prior permission.
The premise, both the units are one.
That has been negative. That has been negative.
Counting or taking the number of workmen working. If you take into consideration both the units, it would be more than 100, and hence 25O need to be followed.
That has been negative.
Point is there, but the only thing is, merely because they have invoked 25O and sought a prosecution, would not disentitle them this reference.
My lord, it will. I tell you, lordships, why. Now, please look at the scheme of 25O. My lord, before that, let me point out to your lordship that document.
But in the absence of any finding, there is a finding.
Any what, my lord?
According to Mr. Raghavan, there is a finding which has come, both the units are not one.
Correct.
They are not one unit. They are separate, functionally they are separate. If they are functionally separate, ultimately the really foundation of your representation, if at all we agree with you, is that both the units are one. It is a functional integrality. If that has been not accepted while deciding that 25O complaint, and you have not challenged, where do you stand?
My lord, I stand on an entirely different footing, my lord. I'll explain it this way. The workman, my lord, under the ID Act has alternative remedies. One for prosecution as well as for dispute. In his dispute, he can seek reinstatement.
Right? Yeah,
Please.
you on that. That's what we have put it to
Please.
Mr. Raghavan. You will have a remedy even under 25O and seek a
Yes.
reference. But
Yes.
once in a 25O order, there is a finding of fact which is against you that they are both not functionally together.
Please.
Then whether your reference would survive and even your prosecution under 25O would be sustainable.
My lord, my prosecution would not be sustainable because this is a finding of the government. But what the Honorable Supreme Court says is that the question of functional integrality is a highly detailed question of fact which requires adjudication. I've produced the judgment of the Honorable Supreme Court in ACC Cements. So that requires adjudication. The order passed was a government order. It was not after adjudication, my lord. Please.
Finding which will be taken against you, which you have accepted.
No, my lord.
If you have not challenged it.
My submission is that's the finding on penalty, my lord. The union has decided not to pursue the penalty procedure, my lord. Now the penalty please.
Procedure based on a fact.
My lord.
Fact is
Please.
getting the point. See, that need to be. If there is a finding which has come, surely it will be taken against you. Look here, that's a finding.
That would be considered by the Learned Industrial Tribunal when this matter is taken up, my lord.
Putting it to you.
Please.
If any finding has come, because what is the foundation insofar as the reference is concerned? Both are one.
Please.
That has not been accepted in separate proceedings.
That's an
You have not challenged. How would you answer that?
My lord, my submission is this. There are two independent remedies as my lordship has mentioned. The workers, what are they interested in? They are interested in reinstatement. That is what they are pursuing under this. In respect of throwing the management into jail, my lord, they suffered an order, no doubt, saying that 25O, we will not impose any penalty under 25O. But that cannot disentitle them to seek reference of the dispute, my lord, on merit.
Why we are saying
Please.
25O you are alleging because they are more than 100.
Please, functional integrality.
Fine together.
Yes.
If separately, they are less than 100.
Yes.
That's right?
Yes.
Yes, Mr. Arun, you can tell.
Now, if your lordship will kindly look at that order, my lord, which has been produced before your lordships along with a memo dated 5th of February 2022. It is an order, my lord, dated 22nd of January 2021. Yes, my lord, it is.
Did you file?
My lord, it has been filed on 4th February 2022. May we assist the court officer, my lord, to locate that? We have, my lord. One more copy. My copy, I have marked it, that's why. My lord, we have a marked copy. Would your lordships permit us? Please excuse us, my lord, for the marking. We all lordships. My lord, may I read this, my lord? It's a short order. This, our one copy, you one more, no problem. This case has arisen out of a letter dated 25/7/2016, submitted by the petitioner union to this authority to grant permission to the petitioner trade union to prosecute the respondent employers for the alleged violation of Section 25 FFA of the Industrial Disputes Act, hereinafter referred to as the Act. Brief facts. Petitioner union in the letter dated so-and-so has challenged the illegitimate closure of the respondent establishment in Tumkur, which is a clear violation of Section 25 of the Act. They have also alleged that the action of the management is also a violation of Section 25F and 25G of the ID Act. 25G and 25F of the ID Act. They were further alleged that the closure is a real motivated mala fide and mere pretense. Therefore, they have prayed this authority to give them permission to prosecute the respondent management in the interest of justice. The respondent management has on 31/8/2017 submitted the written objections to the complaint filed by the petitioner union. In the written objections, they have stated as we wish to submit that as on the date of closure of our Tumkur unit, we had workforce of far less than 100 workmen. You may note that Section 25O is attracted only with respect to industrial establishments having more than 100 workmen. On the date of closure and also in the preceding 12 months therefrom, our Tumkur unit had less than 100 workmen, and this has been acknowledged by the union in their representation. Point for consideration. On the basis of the submissions made before me and the document submitted, the limited point which arises for my consideration in this case is whether the petitioner union has to be given the permission to prosecute the respondent management for the alleged violation Section 25O and 25 FFA of the Act in respect of its establishment in Tumkur. My findings. Section 25 FFA requires the employer who intends to close down an undertaking to give notice of at least 60 days in the prescribed form before the intended closure. Similarly, 25O requires the employers to apply for permission to the appropriate government at least 90 days before the date on which the intended closure becomes effective. However, the most important point which has to be noted in this particular case is that according to Section 25K of the Act, for the application of these provisions, there should not be less than 100 workmen employed on an average per working day for the preceding 12 months. In this particular case, the contention of the respondent management is that the strength of the respondent management on the day of closure is less than 100. Hence, the said provision is not applicable to them. This report submitted by the Assistant Labour Commissioner Division Number 4, Bangalore, which is on record, states that the strength of the respondent management was 66 as on the date of closure. However, it is a contention of the petitioner union that the respondent management has one unit at Tumkur and one unit at Bangalore. Total strength of both the units put together is more than 100, and therefore, according to the petitioner union, respondent management is bound by the provisions of Section 25O and 25 FFA. It is also on record that respondent management has given a notice as prescribed on 9/1/2016, which is received on 13/1/2016 by this office. However, this notice was not in the prescribed form. The Assistant Labour Commissioner Division Number 4, Bangalore, in his report dated so-and-so, has very clearly stated that even though the notice of closure submitted on 9/1/2016 is not in the prescribed form, it can be deemed that the notice has been duly served. The said report of Assistant Labour Commissioner Division Number 4 has also been adverted to by the Honorable High Court of Karnataka in his judgment in writ petition number 5864 of 2018. There is no dispute that the establishment at Tumkur has less than 100 workmen. Your Lordship may note that is a first question of fact. There is also no dispute that the units function in Tumkur and Bangalore are independent units for the purposes of registration or compliances under the Factories Act or other labor legislations. In the present case, though the respondent management, in spite of their contention that the provision 25O and 25 FFA is not applicable to them, have submitted the notice as prescribed under Section 25 FFA, there is only a minor lapse of the notice not being in proper form, in National Kamgar Union, Honorable Supreme Court of India has opined that a notice which was given in the form of a letter could still be accepted and felt that all the requirements of 25 FFA has been complied with. Therefore, for the following reasons, I am of the opinion that the grounds alleged by the respondent union are not sufficient for the following reasons to give them the permission to prosecution of respondent management. Petitioner union has not placed substantial material before this authority to come to the conclusion that the units at Tumkur and Bangalore are one and the same. The respondent management have already given a notice dated so-and-so received by this authority on 13/1/2016. In the light of the opinion of the Supreme Court in the case cited above, a minor variance in the format of notice should not be considered very seriously. This authority keeps open the questions of disputes in illegal issues, etc., open. This paragraph, my lord, I tell you not just, my lord, this paragraph, all that this paragraph will say is that the remedy available elsewhere will not be prejudiced because of the findings in this order. That's how it says. Yes.
Whatever has been said in this order would not come in the way of their seeking any other remedy.
Quite right. No difficulty. Now, my lord, please see 25O, the remedy which is available. This is the point. Your lordships are right, my lord. Now, 10, para 10. No, my lord. No, it's not. Para 10 read with provisions of 25O. 25O itself provides the remedy. That's the one that's open. What is open is 25O remedy. Kindly see 25O for a minute, my lord. No, my lord. Kindly see 25O because this is an order under 25O. It can't be, my lord, that it is, you pass an order on the left hand and the right hand say, put it in the bin.
But that, this case is limited to the point of giving permission to the.
Quite right. But on the basis of the fact, but on the basis of the fact that the two units are not one. My lord, that is the ultimate remedy, my lord. I'm not on the remedy. My lord, there are two remedies available. My lord. I agree with that. But if the foundation for both the remedies is a question of fact, then it can't be good for one, bad for the other. What is sauce for the goose is sauce for the gander.
That plea would be available to you before the reference court.
My lord, but then the remedy is totally different. Kindly see 25O. Otherwise, 25O, if 25O and section 10 are to overlap, then one is rendered odious.
The challenge to a reference would be very limited.
Very limited.
The issue, the reference itself is barred by law.
That is my case. There is no industrial dispute. My question is, my lord, the point I place for your lordship's consideration is that in the absence of the existence of an industrial dispute de facto, there can be no reference. That is the point I'm placing for your lordship's consideration. My lord, I understand, my lord, that the scope of interference when a reference is challenged is limited. Your lordships will not adjudicate on the merits or otherwise, or correctness or otherwise of the claims of both the parties. I bow down, my lord, I bow down.
It can be an eventuality. What can be an industrial dispute? Surely it concerns workman. The person concerned is a not workman. Possibly you can challenge a reference. Look here, he is not a workman, he is an officer. All those grounds which you will take as a workman. So no industrial dispute, must work. But when a fact is involved, the determination or a conclusion on that fact would be within the scope of this court or a single judge or this court in 226, and to say that in the absence of an industrial dispute, the reference is bad, or we leave it to the reference court to decide even the aspect of industrial dispute, because there would be a issue framed on that, whether that could be whether the dispute is actually an industrial dispute for various reasons. So we should leave it to the reference court to decide, or we decide ourselves that this is no industrial dispute. Because of the fact that the basis, the foundation, the very foundation on which they are seeking, they have sought the reference, is that both the units are have a functional integrality, and hence, or doesn't have the functional integrality, and hence there is no industrial dispute. So the reference is bad. Are we to say so?
Lord, my respectful answer to your lordship's query, my lord, is this: if in fact there is no industrial dispute, then, my lord, in addition to the questions that your lordships said, whether you're a workman, whether you're an employer, whether there's a relationship of employer-employee between you, whether you're a workman at all, or you're an officer and therefore not a workman. In addition to that ground, my lord, if there is a de facto closure, then there can be no reference. Insofar as closure is concerned, if there is a de facto closure, my lord, having regard to the judgment of the Honorable Supreme Court, my lord, in Pottery Mazdoor, there can be no industrial dispute. Therefore, my lord, your lordships are entitled to go into the question as to whether, having regard to the material on record, whether there is a dispute, not which way it will swing. Therefore, my lord, your lordships can, in answer to my lord's query, can the court go into it? The court can go into it for the limited purpose of finding out as to whether, in fact, there is an industrial dispute, not whether the dispute is justified, not justified, who is right, who is wrong. No, my lord, that your lordships cannot go into. And now, therefore, what is the basis on which the dispute is sought to be sustained? I am not saying the claim is sought to be sustained. The dispute is sought to be sustained. Dispute is sought to be sustained on the ground that there is functional integrity. I am now pointing out to your lordships, my lord, on the question of functional integrity, there is a finding. Purport, my lord, is that the remedy under 25O is not barred. Now look at 25O. But 25O provides a remedy. They are not remediless.
Just see para 10 of the.
Yes, my lord, I will. Exactly, my lord. I will, my lord. This authority keeps open the questions of disputes in any legal issues which may be pending before any other authority between the petitioner union and the respondent management. This case is limited to the point of giving permission to the petitioner union for permission for prosecute the respondent management for the alleged violation of section 25 FFA and 25O of the Act in closing down its unit in Tumkur.
The prosecution under 25. Any other proceeding which are pending?
Yes, that is what is provided for, my lord, independent of the provision for prosecution for violation of 25O. 25O itself contemplates a dispute. It is a parallel remedy given in addition to section 10. Therefore, my lord, the remedy must be to say that arising out of this order, there is an industrial dispute. Kindly see the provision.
So, but what is being said is, even any legal issue which may be pending before any other.
That's right, my lord, because it's pending before your lordships. It can't be obviously, my lord.
Right.
Obviously.
Even by the time they had sought reference has been made.
Yes, and it was pending before this court. So therefore, my lord.
So that means what was said by the authority is even this reference which is pending, challenge to the reference being pending.
Naturally, my lord. Naturally, my lord.
So what has been said by him insofar as the functional integrity is only confined to
my lord,
the issue before him.
Elsewhere. Obviously, my lord. Because the matter is pending before this honorable court. Yeah, I mean, he can't say anything more.
It appears it is not said in that sense.
It is said in two senses, my lord. One is because it's pending before this honorable court. Second, my lord, is that if you want to, what the finding you have recorded here is without affecting your rights under 25O. Kindly see the reference under 25, because it's a very, my lord, 25O and section 10, if I may say so, operate, my lord, in parallel lines. Even an order under 25O, granting permission, refusing permission, can itself become an industrial dispute. Therefore, the finding that I have recorded here will not bind anybody. My jurisdiction is only to decide as to whether I should give permission to prosecute or not. Suppose, my lord, there is a reference that could be made under 25O. Labor court also is not bound by, the industrial tribunal is also not bound by the finding recorded by the chief secretary. Yes.
So, if their case is there is a functional integrity and evidence can be led before the tribunal or the labor court for it to come to a conclusion whether there is a functional integrity or not, which would actually determine the issue of closure, why not they should be relegated to.
My lord, my respect to submission, that's not permissible in the present reference. Yes. In the present reference, it can't be done. Kindly see, my lord, if therefore, kindly see the scheme of 25O.
Yes.
An employer who intends to close down an undertaking of an industrial establishment to which this chapter applies shall, in the prescribed manner, apply for prior permission at least 90 days before the date on which the intended closure is to become effective to the appropriate government, stating clearly the reasons for the intended closure of the undertaking, and a copy of such application shall be served simultaneously on the representatives of the workmen in the prescribed manner. I pause for a moment here, my lord. Please keep the order that has been passed aside for a minute. Let me assume that there was no order. The very fact that you make an application under 25O, saying, please give me permission to prosecute the management for violation of 25O, presupposes that in fact 25O has been violated. How is 25O violated? Because you have closed down without taking prior permission. Factum of closure is the very basis, my lord, on which a complaint for violation of 25O can be filed. You can't on the one hand say there's no closure. On the other hand, say there's a 25O violation. How does it sustain, my lord, from the point of view of the union, I ask myself.
Just observing this.
Yes, my lord, yes.
Reference, functional integrality, insofar as both these things. When it comes to 25O, because there is a limitation or there is a benchmark or there is a procedure contemplates that only in the eventuality where there are 100 or more workmen are working, you should take prior approval of the government. Now, what is their case is? Their case is only this: if you combine both the units, it would be 100 and more. So if it is 100 and more, the requirement under 25O for closure also need to be taken.
Correct, correct. It presupposes the fact that the Tumkur unit has been closed. They can't on the one hand say there's no closure. On the other hand, say there is violation of 25O. It doesn't, why did they make an application for permission to prosecute on the ground that 25O has been violated based on two facts? One, de facto Tumkur has been closed. Add Tumkur and Bangalore, more than 100. Without Tumkur being closed, the 25O prosecution application cannot lie.
Take it, what we have said is right. Tumkur, that shows, presupposes they accept Tumkur
Closed.
But they say if Tumkur has closed, you accommodate.
That is the difference. So therefore, my lord, therefore, your lordship, therefore, my lord, there are two questions. One is, de facto has Tumkur been closed? I don't think, my lord, they can escape from their own stance. Yes. Now the only question is whether there is functional integrality. It boils only to that one question.
Their case,
yes.
Close, you accommodate.
Exactly. That is not their case.
That's what she.
Now, one sentence where they say that please accommodate me in Bangalore. One sentence in their entire representation. My lord, I don't have a case. One sentence. My lord, now please see, my lord. Now please see the effect of the order that has been passed having regard to the scheme of 25O. Now, my lord, I read to you on lordship's 2501. Now please see 2502. Where an application for permission has been made under subsection 1. The appropriate government, after making such inquiry as it thinks fit, and after giving a reasonable opportunity of being heard to the employer, the workman, and the persons interested in such closure, may, having regard to the genuineness and adequacy of the reasons stated by the employer, the interest of the general public and all other relevant factors, by order and for reasons to be recorded in writing, grant or refuse to grant such permission, and a copy of such order shall be communicated to the employer and workman. Where an application has been made under subsection 1 and the appropriate government does not communicate the order granting or refusing to grant permission to the employer within a period of 60 days from the date on which such application is made, permission applied for shall be deemed to have been granted on the expiration of the said period of 60 days. An order of the appropriate government granting or refusing to grant permission shall, subject to provisions of subsection 5, now that's what I'm saying, subject to provisions of subsection 5, be final and binding on all the parties and shall remain in force for 1 year from the date of such order. The appropriate government may, either on its own motion or on the application made by the employer or any workman, review its order granting or refusing to grant permission in subsection 2 or refer the matter to the tribunal for adjudication. Therefore, my lord, if the grievance was that 25O is applicable because of functional integrality which has been refused, the remedy of the workman was to have recourse to 25O5. And then say, here is the government which has made an order refusing to grant me permission, forget permission of prosecuting, nothing comes out of putting the management in jail. I want this question as to whether there is functional integrality between Tumkur and Bangalore and they can be considered to be one unit to be decided on a reference. Please make a reference on a 25 file. That should have been the
Then what is the difference between this?
Oh, there's a world of difference, my lord. This 2505 reference is in spite of the fact that there is a de facto closure. That your lordship gets it at subsection 7, subsection 6.
This reference under 2502 confine itself to the, if they succeed, there is a functional integrality and they have not taken permission, lead to prosecution.
No, my lord. Kindly see, the answer to your lordship's question, I believe, my lord, is found in 2506. Not necessarily only process. They get their benefit also. Yes, my lord. Yes, my lord. Where no application for permission under subsection 1 is made, that is the grievance, within the period specified therein, or where the permission for closure has been refused, the closure of the undertaking shall be deemed to be illegal from the date of closure, and the workman shall be entitled to all the benefits under any law for the time being enforced, as if the undertaking had not been closed down. Therefore, my lord, the correct remedy, if I may say so, my lord, with all the humility at my command, is to seek for a reference under section 2506.
But the only difference it appears what we can foresee is maybe in the reference under 10, possibly they can go back. They can go back in their employment. No.
No, my lord.
Will be still confined to the back pages or
That's all.
as is the contemplated.
Yes, 2506. And if there is an order that has been passed holding that there is no functional integrality, then the only remedy available is 2506. They will get all the benefits also.
No, we were just only thinking, suppose for a moment, this reference which is under challenge.
Goes.
They succeed. Let's assume we don't agree with you.
Oh, they succeed. And then they may get a job. They may be, if the tribunal, my lord, is entitled to come to a conclusion that notwithstanding the finding recorded by the chief secretary, still there is functional integrality, they may be entitled to an order of reinstatement. Yes, yes. That's now the question. There is one important difference, my lord, that insofar as the reference under section 10, as has been done in the instant case, is concerned, it proceeds on the basis that de facto there is no closure. Whereas, insofar as the reference under 2506 is concerned, in spite of the fact that there is a de facto closure, still they will be deemed to be in employment. That is the difference. Because if there's closure, my lord, the relationship of employer and workman comes to an end. That's the end of the relationship. However, whatever may be the consequence. That is why, my lord, this direction, that paragraph number 10 of the order passed by the authority exercising power under section 25O for permission to prosecute, has to be understood in the context of the scheme of the act. It is not divorced. Therefore, the authority is saying, look, whatever I am saying, of course, is subject to 2506. I mean, they may not have said in so many words, but that's how we have to understand the scheme of the act. Otherwise, my lord, the provision under 10 and 2506, I ask myself, how do we reconcile the two? In every case, there can be a reference under 10 and 25O order will go. Now, my lord, in this case, it was an order for permission to prosecute. Suppose in a given case, my lord, it was an application that had been filed by the management for permission to close. And the authority says, well, you might have filed it, but I don't think that there is any permission required. Do what you want.
My lord, if I may
Then what happens?
What you are saying, this observation is only to the extent if there is a reference under 25.
This finding will not bind.
This would not.
Absolutely.
if I may-
Absolutely. This finding of fact, they are entitled, my lord, to go before the reference court under 2506 to adduce all the evidence to show that the finding that has been recorded by the additional chief secretary, that there is no functional integrality and I am not going to add Tumkur and Bangalore to come to a conclusion that it is one industrial establishment is wrong, both in fact and in law. To say that 66 employees are there in Tumkur is wrong. Independently, Tumkur has 100 plus. All that is how it is. It is not as if they are closed of all their remedy.
Yes.
Now, my lord, having and in the instant case, my lord, there are a few more facts that will complete the jigsaw puzzle. The pieces are, my lord, they have received compensation under 25 FFA. Factory license has been surrendered. Machinery has been sold. Property, in fact, has been sold. So the fact that Tumkur unit has come to a close is indisputable. The question, therefore, that remains on is whether there is functional integrality. Functional integrality in the instant case cannot be decided as a standalone question. It has to be decided in the context of the proceedings under 25O, which provides a remedy under 2506. Therefore, my lord, remedy under section 10 is gone now. It's over. Otherwise, my lord, it can't be that there are two remedies. One chambers in the government saying, yes, I am referring under 10. Another chambers under section 10. Another chamber, my lord, looking at the question under 25 was saying there is no functional integrity. It becomes a whole thing becomes contradictory, and it is not conducive to industrial peace, which is the whole object of this law. It is not, my lord, for multiplication of disputes. It should be one. Everything must come under one. Either go under 10 or 25O. Having taken the route of complaining 25O, my respectful submission is 2506 cannot be given a go by. It is a complete code by itself.
Can I clarify on this point of 2505, my lord? Oh, sorry.
Few more minutes. Now, my lord, on this, please look at a judgment of the learned division bench of the Jharkhand High Court, my lord, which I thought was relevant. I should place it for your lordship's kind consideration. Lord, if your lordship will kindly see, my lord, where is my copy? Where is my copy? Just. Recording. Now, where is my copy? I don't have. My lord, please be kind enough, my lord, to the judgment of the Honorable Division Bench of the Jharkhand High Court, which your lordships will find at page 4, my lord, of the, I may just point out your lordships, my lord, first two paragraphs, and then come to the relevant law laid down. Why judgment dated so-and-so, passed in civil appeal number so-and-so, their lordships of the Supreme Court, by setting aside the division bench judgment of the Patna High Court in two writ petitions being so-and-so, have remitted to the division bench of this court the aforesaid two appeals for fresh disposal in accordance with law. Both the writ applications related to two references made by the state government under the Industrial Disputes Act. The appellant management BASF Limited had challenged the legality, validity, and correctness of these two references in the aforesaid two writ applications, which came to be dismissed by learned single judge of the Patna High Court. Appeals under clause 10 of the letters patent having been filed by the appellant also meeting the same fate. The appellant had moved the Supreme Court, and as noticed above, their lordship of the Honorable Supreme Court, while setting aside the impugned orders of the division bench, remitted the appeals for fresh disposal. The two references made in the two writ applications may be reproduced verbatim. These read as reference number 1, whether the closure of BASF declared by the management is justified. If not, what relief the workmen of the said factory are entitled to. Reference number 2, whether not to introduce the reconstruction works of the plant under the defined purpose of voluntary retirement scheme and to enforce its closure by BASF Limited, Bokaro, is justified. If not, what relief under this scheme the workmen are entitled to. The ground on which the High Court of Patna had dismissed the writ applications in LP was that the Industrial Tribunal itself was competent to decide the question of legality or validity of the references. The Supreme Court, the aforesaid judgment, did not agree with the aforesaid view of the High Court. We court. Now, this quotation is relevant, my lord, if I may point. In our opinion, it is not open to the Industrial Tribunal to determine whether a reference made to it is justified or otherwise legally valid. It is also not open to the Industrial Tribunal to decide the question whether closure of the establishment is justified. in a reference made by the state government under the Industrial Disputes Act. The issues involved in the references were required to be decided by the High Court after taking into consideration all relevant facts. The High Court could not relegate the parties to the Industrial Tribunal for determination of those questions. Under these circumstances, the impugned order of the division bench of the High Court cannot be sustained. The appeals are thus allowed, and the impugned order of the division bench of the High Court are set aside. Matters are remitted to the division bench of the Jharkhand High Court for their fresh disposal in accordance with law. So, my lord, first proposition is settled, my lord, that just correctness or otherwise of a reference cannot be gone into by that. Your lordships have to decide it. Now, my lord, please see, my lord, 25 FFA is quoted in paragraph number 4, having regard to chapters 5A and 5B. I will now straight away take your lordship to, my lord, paragraph number 6. At page 4, my lord, of the judgment. A very short point is involved for consideration in this case. In both the impugned references as made by the state government, what has been referred for adjudication to the Industrial Tribunal is as to whether the closure of the appellant undertaking established was justified or not. Even though in reference number 2, apparently the issue is about the non-introduction of the reconstruction works of the plant under the defined purpose of VRS scheme, the pith and substance of reference number 2 is the closure of the establishment itself. And since in effect and substance relate to and directly are linked with the issue of closure of the undertaking establishment. In the present case, from the material on record and unimpeachable documentary evidence that has been produced before us by the appellant and not controverted by the respondents, undoubtedly the establishment of the appellant was at the relevant time being undoubtedly and apparently referable to the requirements as projected in section 25 FFA of the Act. The establishment of the appellant was not employing more than 100 workmen. It is only if an industrial establishment where more than 100 workmen were employed on an average per working day for the preceding 12 months that the requirements contained in section 25 would be attracted. Section 25K of the Act clearly and unequivocally lays down that the provisions of chapter 5B shall be applicable only to industrial establishments if 100 or more workmen were employed on an average per working day for the preceding 12 months. If in an industrial establishment this was not the case, and if the number of workmen employed was less than 100, 25O of the Act would not at all be attracted. We are saying so with repeated emphasis only to highlight the fact that non-applicability of 25O clearly means that prior permission of the appropriate government is not the requirement of law in such a case for an intended closure to become effective. The only provision, therefore, which is held applicable in respect of an industrial establishment on an undertaking is section 25 FFA, which merely lays down the requirement of the employer serving at least 60 days notice in the prescribed manner on an appropriate government, stating its intention of closing out its undertaking and the reasons for such intended closure. In this case, we are not called upon to decide any issue arising out of the proviso to subsection 1 of section 25 FFA because the learned counsel for the appellant has himself suggested to us that we may presume that the number of workmen employed was more than 50 at the relevant point of time. Of course, it was less than 100. Then no difficulty. Same thing, my lord. We are saying the same thing. 25 FFA is applicable because it is more than 50. No difficulty. If therefore only 25 FFA is attracted and held applicable in the case of the appellant, it was not open to the state government to make a reference to industrial tribunal questioning the justifiability of the closure or subjecting the justifiability to judicial adjudication of the industrial tribunal. This is the point, my lord. If therefore only 25 FFA is attracted, which is the point in this case, there is no dispute about it. In fact, their allegation is 25 FFA has not been complied with. He is attracted and held applicable in the case of the appellant. It was not open to the state government to make a reference to the industrial tribunal, questioning the justifiability of the closure or subjecting the justifiability to judicial adjudication by the industrial tribunal. The justifiability of an action taken or contemplated to be taken under 25 FFA is not open to judicial scrutiny in normal circumstances. What is open to judicial scrutiny or what may form the subject matter of a reference under the Act is the legality of the action taken or purported to be taken or contemplated to be taken under 25 FFA of the Act. Justification of the closure or the intended closure cannot be made the subject matter of reference if the closure is under 25 FFA of the Act. That is the distinction, my lord, between, now next kindly see the distinction between 25 FFA and 25O. Undoubtedly, of course, justifiability of a closure can be made the subject matter of a reference if the closure is ordered or resorted to under 25O of the Act. Scheme of 25O of the Act clearly suggests that once the employer seeks permission of the appropriate government in terms of subsection 1 for closing the industrial establishment, in terms of subsection 2, the appropriate government, after making inquiry and after giving a reasonable opportunity to all concerned of being heard and having regard to the genuineness and adequacy of the reasons, the interest of the general public and other relevant factors by order and for reasons to be recorded in writing, grant or refuse to grant permission asked for. Subsection 5 of section 25O clearly lays down that the appropriate government may either review its order granting or refusing to grant permission for closure, or it may refer the matter to a tribunal for adjudication. It means that even if permission for closure has been granted by the appropriate government, such permission is always liable to be reviewed by the government on its own motion or an application by either of the parties. The dispute regarding grant of such permission or its refusal can be referred to adjudication to industrial tribunal. When therefore such a reference is made and the tribunal starts the process of adjudication, undoubtedly justifiability of the closure or the intended closure would be relevant and important issue coming up in the process of adjudication. What would be adjudicated upon by the tribunal in such a situation would be the order of the appropriate government granting permission to close or refusing to grant such permission. Justifiability of the closure would therefore be the most important relevant issue. We are saying so at the risk of repetition because justifiability of the closure would be flowing from the order of the government granting permission to close, and this order being referred to adjudication to the tribunal. Justifiability part of it cannot escape the adjudicatory process. Such is not the case with respect to an undertaking or an establishment if the closure happens under section 25 FFA. As your lordships have seen, my lord, 25 FFA is in chapter 5A, not under 5B. Therefore, if it is more than 50, it applies. It is in our case, 25 FFA applies, no difficulty. And the order of the chief secretary now is 25 FFA applies, not 25O. We are saying so because no permission of the government is required for effecting such a closure. All that is required is the serving of a notice in the prescribed form. The only requirement, therefore, of 25 FFA is whether a notice has been served upon. Whether the closure is justified or not is not the requirement of 25 FFA of the Act. Therefore, if an industrial establishment or undertaking is covered by 25 FFA and not covered by Chapter 5B, the only requirement which an employer is to fulfill and follow is the serving of a notice in prescribed manner. The employer does not need any permission from the appropriate government. Therefore, the employer is not called upon to show to anyone whether the closure is justified or not. Because correspondingly, no one has any jurisdiction, authority, or power to call upon an employer to justify the closure. If therefore the law does not require a justification part to be established, demonstrated, shown, or proved, the same cannot be made the subject matter of a reference for attacking the closure of the undertaking or the establishment. If justifiability therefore cannot be brought into the issue, any reference to the industrial tribunal asking the tribunal to examine the justifiability of the closure undoubtedly is invalid, illegal, and dehors section 25 FFA and other provisions of the Act. So, my lord, I believe, my lord, that. And now, my lord, your lordship may kindly turn to paragraph number 13, my lord, in this judgment. I thought, my lord, that the Honorable Division Bench of the High Court of Jharkhand had analyzed the provisions, my lord, of Chapter 5A, 5B, 25 FFA, 25O, 25O5, reference under Section 10, scope of the two. My lord, yes, my lord.
There is no functional integrality as is being urged here. There is only one unit, less than 100, has been closed. Permission, approval, prior approval not required, only you have to inform it. And in that situation, what the court was saying was closure that cannot be contested. What is being contested? Something relatable to that if you have any issue. Unlike that case, insofar as this case is concerned, suppose for a moment, let's assume for a moment there was no this 25O prosecution. And their case has been this, subject to what you say, subject to what we also say. Whether they have laid a foundation by stating that Bangalore and Tumkur there is a functional integrality and hence the closure could not have been effective.
Functional integrality to be understood as if one dies, the other dies. That is how the law has. Your lordship may kindly see, my lord, I'll show your lordship one judgment also on that point. Functional integrality is this unit is dependent upon this unit. If this unit dies, this unit will not survive. If the two units are able to survive independently, there is no functional integrality.
No, but interchangeability, suppose there is the interstate transfer between both.
No, that's not their case, my lord. I mean, I understand, my lord, all these could be.
Which may.
Maybe. My lord, I don't know whether even unit transfer will amount to functional integrality. No, my lord, integrality as understood, as I see, my lord, in labor law is where one cannot survive without the other.
Let's say you for a moment, one person is transferred there and their person is brought here. It would effectively become a one unit because ultimately, for the purpose of employment or for the purpose of seniority or other aspects, they are.
My lord, maybe, my lord, I really do not want to, maybe, my lord, your lordships are right. I have not examined it from that point of view, my lord. Maybe your lordships are right. I bow down, my lord. But in the facts of the present case, that question doesn't arise. I shall look at it, my lord, no doubt what your lordships are putting. And there are few, yes, my lord. There are few other aspects that I want to point out, my lord. Therefore, please look at para 13 of this order. And there's something more I want to point out, your lordships. Viewed from any angle, therefore, either from the justifiability point of view or otherwise, we have no doubt in my mind that the two references in question were framed Dehors Chapter 5A, particularly Section 25 FFA of the Industrial Disputes Act. Undoubtedly, Chapter 5B, particularly 25 was not applicable and could not be attracted in this case, and therefore the Industrial Tribunal had no jurisdiction to adjudicate upon the issues forming the subject matter of the aforesaid two references. So this is a case where reference was challenged, and all this discussion took place in the context of a challenge to a reference, having regard to a remand order of the Honorable Apex Court, my lord.
Both were on closure, the references.
Yes. My lord, here, wording is not important, my lord. What is the pith and substance of the reference? Kindly see the reference itself in this case. Without deciding on the question of, please be kind enough to turn to page 73. Whether the management of Vinayaka CNC is justified in not providing employment to workmen by closing down. So that the reference itself admits that there is a closing down. And the reference is not, why can't you provide employment in Bangalore? There's no such reference also. But that is because there in the representation, there is not one sentence they say, we can go and be employed in Bangalore. We are willing to be employed in Bangalore. My lord, functional integrality, they also have to say, well, I am ready to go to Bangalore. I am ready to take up that employment. My lord, that should be they should first say, I'm sorry, you are saying.
What says, rather than saying closing down, they should have sought a reference that you have closed down, but you provide employment.
Exactly. And for that, the fundamental requirement should be the employee is coming and telling the management, sir, I am willing to go to Bangalore, sir. You are no doubt closed down. I can't help it, but please give me a job in Bangalore. There should be that, at least that move from their side. It can't everything be in the air. It can't be that the tribunal will say, yes, go to Bangalore. And the employer is saying, sorry, I will not go to Bangalore. Whole exercise is futility. Therefore, my lord, the minimum requirement should have been for the employees to come and say that.
If they express themselves that they will go to the Bangalore, then they can't carry the closure.
Exactly. That's precisely what that was my submission, my lord. How can they have both these arguments go simultaneously? One, I want to go to Bangalore. Functional integrality, I want a job in Bangalore. How can you say that unless you are able to say there is de facto no closure in Tumkur? You admit de facto closure in Tumkur and then say, I'm willing to go to Bangalore. Can we read all that into this reference is the question, my lord, I ask myself and place it humbly for your lordship's consideration.
Yes.
And this is not like, my lord, a civil court. Any other order can't be done. And it's not, my lord, like in the plaint that we always say, or in writ petition that we filed before your lordship, any other order as this honorable court may deem fit to grant in the facts and circumstances of the case. We do it day in and day out, my lord, when we file plaints in the court.
You have 226.
That's the beauty. 226. Yes, my lord. That is the beauty. Even without a prayer, it can be. Yes. Yes. Postcard. Absolutely. But no doubt. Constitutional remedy, my lord. This is not that. Reference is not. Tribunal of limited jurisdiction can't go beyond the reference. Therefore, you have to read the reference. They can't even modify the reference. They can't return the reference. They can't do nothing.
Jurisdiction because of reference.
Reference. And reference is the last word. And I ask myself the question on the basis of this reference, which on a plain reading of it proceeds on the basis that the Tumkur unit has been closed down. Is it open for them to come and tell your lordships, no, on the basis of this reference, please ask the tribunal to decide as to whether I can be accommodated in Bangalore? Where do I get all this in this reference? They may want to go before the government, ask for a different reference. That is is left to them. They are best advised as to what they want to do. But on the basis of this reference, there cannot be a proceeding before the industrial tribunal submission I make. Now, my lord, I want to place for your lordship's consideration a definition, my lord, which is very important. Your lordship may kindly see section 2KA of the Industrial Disputes Act. If I may trouble your lordship to kindly see section 2KA, my lord. Industrial establishment or undertaking means an establishment or undertaking in which an industry is carried on, provided that where several activities are carried on in an establishment or undertaking and only one or some of such activities is or are an industry or industries, then if any unit of such establishment undertaking carrying on activity being industry is severable from the other unit or units of such establishment or undertaking, such unit shall be deemed to be a separate industrial establishment or undertaking. Labor laws. Therefore, my lord, what is it that is required as a matter of fact, even to allege that the activity in Tumkur is not severable from the activity in Bangalore. Therefore, there is a functional integrality. In other words, if Tumkur does not function, Bangalore will die.
For purposes of other labor laws, they were separate units.
Separate unit. There is a separate, yes, my lord, there is a separate factory license in which we have surrendered also. We have surrendered the factory license. No. On the contrary, even today, in the Tumkur unit is working. And Bangalore unit is working, my lord. 2016 was the closure of the Tumkur unit. We are now 8 years. So it's in law, my lord, my learned friend is right. But there should be a factual foundation for the legal submission, which in my humble submission, my lord, is absent in the instant case, especially because of section 2KA. My lord, in fact, your lordship may kindly turn, my lord, to page 252. Let us see what was their prayer before the labor officer on the basis of which this reference came. Your lordship may kindly turn to page 252. Do they say, please take me to Bangalore? Not even a whisper about it, my lord. That the same parts or same products are being manufactured in Tumkur and the same products are being manufactured in Bangalore does not make it functionally integral. I may have a unit here to serve customers who are close to me. I may have it can be done. It doesn't make it function. Now, therefore, in that context, please see paragraph number 17 at page 252. In view of the above stated reasons and under circumstances, we humbly request this honorable authority to admit this dispute in conciliation and in the meanwhile advise the management withdraw their illegal and unjustified closure order and provide work to all the 65 workmen with continued service, etc. I ask myself, where do they say I want to go to Bangalore? And all that they can rely upon, if at all, my lord, is that one is at page 251, line number 2, which does not satisfy the requirements of law. The management is running its show in full swing by way of producing connecting flange, RQV, pump barrel, etc. in one or other fashion. Yes, correct. Yes, my lord. I am manufacturing it in Bangalore. So, what's a sequitur? Sequitur does not mean that one is functionally integrated to the other. They are two independent standalone units. I have some business here, I cater to the customers here. I have some business here, I cater to the customers there. Hence, management is debarred from closing their establishment. So why, my lord? Lord, this will lead to a very dangerous situation if their contention other side is accepted. If there are 2 units of a industry which are manufacturing same products to cater to the customers in that region, Lord, it happens all the time. Especially when we are talking about auto components, all the ancillary or auto component manufacturers always want to establish the unit where the automobile manufacturer has the factory. It's common. How does it begin in one unit? Suppose the automobile manufacturer closes down one unit. Automatically, I may say, I will also close down my component. What am I going to do keeping it there?
Yes.
So therefore, my lord, there's nothing in this. My lord, let one word be shown on functional integrality. Please see paragraph 14. Paragraph 14 of the same representation. I'll read this, my lord. The management, if at all, wants to close the establishment, they have at first instance has to obtain prior permission from the government as per section 25O, since all the units of the company constitutes one establishment, which has been negative now. Now that is clear, my lord. That as per the purported claim management, they have adopted common standing orders and also erstwhile ventured to transfer the workmen from one unit to another. And further, there is both common balance sheet and unity of ownership and functional integrality. Since more than 100 workmen are working as on the date of alleged closure, the management ought to obtain prior permission from the government for closing any of their establishment. This is the case. Today, it can't be, my lord, that I completely change my case and then say, oh, it doesn't matter. Give me employment in Bangalore. Where have they asked for it? And say, I am willing to go to Bangalore. Tomorrow, my lord, I come to Bangalore, I give a transfer order. They say, no, that is itself is harassment. And I'm also producing for your lordships now, my lord, that even the land has been sold. It's finished. Tumkur is finished. It can't be that stray word, one sentence. And now what is this concept of functional integrality and labor law, my lord? I am not on the law. I am on what is it that you should establish in order to even take it as a pleading of functional integrality. Please look at one judgment, my lord, of the Honorable Bombay High Court on the point, which again, my lord, in my humble submission, lays down the law clearly, and I am placing it for your lordship's kind consideration. Please be kind enough, my lord. Though, of course, it is a judgment of a learned single judge of the Bombay High Court, in fact, my lord, of His Lordship Justice Kapadia, the later Chief Justice of India. And it doesn't really matter, my lord. It is a judgment of the learned single judge. I am placing it for your lordship's consideration. Please look at this judgment. Go to Same. Oh, my lord, it is in the same compilation. Lord, I am given to understand, same compilation. 1992 SEC Online Bombay 568. Please be kind enough to turn to page 10. If your lordships are kind enough to turn, my lord, to paragraph number 15. It is available, my lord, at page number 21 of the compilation of case law that we placed for your lordship's consideration just a while ago. With regard to the contention of the petitioner union, namely that Chapter 5B of the Act has also been violated, I do not find any merit in the submission of the petitioner. At the outset, it may be stated it is now well settled by various judgments of this court as well as the Supreme Court. The 2 establishments, in fact, constitute one establishment if the test of functional integrality applies. Merely because the employees are transferable from one company to the other, or merely because the partners of the 2 firms are common, will not sufficient to come to the conclusion that the test of functional integrality is satisfied. In the case of Dharmsi Moragi, so-and-so, this court laid down the basic test of functional integrality, where the units are functionally so connected that closure of one unit will lead to the closure of the other unit. That, my lord, is functional integrality for the purpose of labor law. This test of functional integrality is also laid down in the judgment of the Supreme Court. In the case of Isha, in the said judgment of the Supreme Court has held, the test of functional integrality to mean that the functions of 2 companies are so interconnected by way of unit of ownership, supervision, and control that closure of one unit directly affects the other. In the present case, petition union had filed two independent separate complaints. In each of the said complaint, there is no averment regarding functional integrity of the two companies. Merely use of that word is not what is important. They should say that the closure of Tumkur will lead to closure of Bangalore. Therefore, there is a functional integrity. And the proof of the pudding, my lord, is in the eating. Bangalore is continuing after 8 years. It was not even alleged that the said two companies were so connected that they should be held as one. I'm sorry. I'm sorry. Anything else to point out?
Yes.
So, my lord, this lays down, my lord, what is this concept of functional integrality as understood in law. One must lead to the death of the other. That is functional integrality. My lord?
Does not speak of death.
Or closure.
Does speak of survival.
Closure.
No, one should survive only if others
Ah,
survive.
yes, yeah. I bow down, my lord. I bow down, my lord. I bow down, my lord. I completely bow down to what your lordships are saying. That's a better way of looking at life than one can survive if the other survives. My lord, I will adopt it, my lord, not only in this case, I will adopt it even in my personal life. Very positive way of looking at it, my lord. My lord, this is my submission, my lord.
We'll start from page 73, that's the reference of.
Please. My lord,
What is the reference sought? What is the reference made? Says that justified in not providing. Remind it. The reference is against the management in Tumkur, not in Bangalore, combined together. Getting the point? So in that sense, the reference presupposes, subject to what you say. There is no integrality between Bangalore and Tumkur. Getting the point? What is saying, the management, this, Tumkur is justified in not providing employment to workmen represented by the secretary by closing down with effect from this. What the reference is? By closing down this, you are not providing employment to them. Who is not? The management at Tumkur. Nothing to do with Bangalore. That's one. If that be so, what is the thrust of this reference is? By closing down. According to Mr. Raghavan, this closure, if you are accepting the closure at Tumkur, not seeking an alternative employment in Bangalore, nor there is a reference to that extent, then that closure of Tumkur is not justiciable. That's the argument. How would you answer that? That's the first thing.
My lord, the constitutional bench of the Supreme Court says that the dispute is crystallized on the pleading of the party. What is the dispute? The government has to send it forward. I read the relevant portions of CP Sarthi of the Honorable Supreme Court, where it says that the government has to consider under Section 10 whether or not a dispute exists. Then it sends it forward. Now here a dispute has been seen to exist by the government, it has sent it forward. But what the exact dispute is, as per the constitutional bench of Supreme Court, is crystallized in terms of the pleadings of the parties. So the fact that, please.
No, this is only so that you can answer. The reference made to a labor court, the labor court will confine itself to the reference. It can't go beyond the reference. By getting jurisdiction because of the reference made. Okay. Now the reference is only this, not providing employment because of the closure of the school.
The second point, if not so, the said workmen are entitled to what? My lord, it should be relief, my lord, not compensation.
If not so, the workmen are entitled to what?
Not compensation, my lord. The word in Kannada is parihara, which means relief, which means the relief of even reinstatement can be ordered as
Reinstatement where?
exactly, my lord. Once I establish functional integrity on the anvil of evidence, my lord, then reinstatement will be with the management, whatever management that is. That's my submission. I cannot say that take me in Bangalore, take me in Mumbai, take me anywhere. Once I establish that the management is one and the establishment is one, then the reinstatement order goes to the management.
Okay. So what you are saying is, in not providing employment to workmen,
Yes.
by closing down Tumkur, though they have closed down Tumkur, they should provide employment in Bangalore.
The second, my lord, is that factum of closure even in Tumkur, my lord, is being disputed by the union. Because closure in its general sense is very different from closure in the definitional sense. The definitional sense, my lord, contemplates a permanent closure. Now, my learned senior has submitted that the property has been sold. That's not within my instructions, my lord. I would not wish to submit on that aspect. The factory license
We are
is-
filing, my lord, the encumbrance certificate, which indicates that the property also has been sold.
even other,
Got something there, Mr.
My lord?
You have said so in your.
No, it was during the pendency of this appeal. No, no.
Come to your representation.
Please.
Which led to that reference.
251 I refer to. As my learned senior read out, my lord, I've clearly said that there's transferability, that there's functional integrality. I refer 251, my lord. In fact, my lord, if my synopsis can be referred to, I've extracted all the relevant.
See, this is the basis for reference, this
Yes.
representation.
Please.
So let's confine to this.
Sure, ma'am. Para 14, my lord. The management, if at all, wants to close the establishment, they have to, at the first instance, has to obtain prior permission from the government as per Section 25O of the Act. Since units 1, 2, and 3 claimed by the management of the company constitutes one establishment. That as per the purported claim of the management, they have adopted one, my lord. This is the first contention. Common standing orders. Secondly, transferability. Erstwhile venture to transfer the workmen from unit to another. Third, common balance sheet.
There is no
Fourth,
unit.
unity of ownership. Fifth, functional integrality. So, my lord, the pleading is there in so far as functional integrality. When my lordship questioned as to transferability, my learned friend mentioned that it's not our case, but it is our case. It is the case made out by us in our pleadings. Secondly, my learned senior referred to Section 22KA of the Industrial Disputes Act. Now, 2KA, my lord, shall I read the full thing, my lord? And then, my lord, since my lord is referring to this, I would also refer 266, which is a rejoinder statement, forms part of the pleadings. I refer at the end of the first paragraph, my lord. The last sentence, actually only the place of employment is closed, not the entire business. Hence, the contention of the management that the Tumkur unit is closed permanently is incorrect and false. I am reading page 266 of our, it's a rejoinder statement, my lord.
Is
266, my lord, 66. The rejoinder statement starts at 264. I am referring at 66, my lord.
Yes.
I refer, my lord, to the last sentence before on the first paragraph, my lord, on the right-hand side. The last sentence, actually only the place of employment is closed and not their entire business. Hence, the contention of the management that the Tumkur unit is closed permanently is incorrect and false.
Supports me. That doesn't make any difference.
This supports
And, my lord,
Who is saying business is closed?
The integrality, what is defined or what is stated in that Bombay judgment is that, let us assume, hypothetically, some of the parts of a product or the vehicle,
please.
let us suppose vehicle, some of the parts of the vehicle are manufactured at one place, some other parts are manufactured at some other place, and if one closes, the other cannot survive.
My lord, that's on.
So that is functional integrality which is spoken of. Of course, the employees may be transferred. Of course, standing on orders may be same. Of course, balance sheet has to be one because ultimate product is one.
Income tax has to be paid.
But if exactly same product is also manufactured at one and same product is also manufactured at another place, but they are not interdependent,
My
then
lord,
there cannot be an integrality. That is what it says.
please. My lord,
Don't-
but that, my lord,
Don't be scared, there are many.
Yes.
My lord, the answer to that, my lord, is very clear in the ACC cement case. On this, on the question of the question of functional integrality, my lord, is a question which the Supreme Court holds, my lord, that no single test can be fixed. Of course, closure test, which is referred by my friend, is one possible test which has been laid down by the Supreme Court. But in ACC Cements, what I'll refer to that provision, that paragraph, my lord. The Supreme Court says that it's a question of fact and there are always a multiplicity of factors which have to be considered. And no single test, such as the test proposed by my learned friend, can apply in every case. So whether or not it's functionally integral depends on the facts and circumstances in the case, and I have to be allowed a opportunity to prove it on evidence before that. I am not, my lord, in a case where I'm challenging, he's not challenging an award. I have not even been given an opportunity to lead evidence on this point. Then, my lord, I refer to section 2KA, which my learned senior referred to. My lord, the proviso is relevant because it talks about when this section is invoked at all. And it is invoked where, I read the proviso, provided that where several activities are carried on in an establishment or undertaking, and only one or some of such activities is or are industry or industries. This is in a case where some do not fall in the ambit of the definition of industry, some fall within the definition of industry. Then you can sever, and the parts which are industry, my lord, would be governed by this act. Here, my lord, it's no one's contention that one is industry, one is not industry. Both are industry. So 2K might not come to the aid of my learned friend. Then, my lord, the contention that I ought to have sought a reference under 2505. That averment, my lord, that remedy is not at all available to me because it arises only once an order has been passed on an application filed by them. They have not even filed an application. If I can read the relevant provision again. This,
They filed a claim petition before the labor court.
I filed my
Yeah,
claim at
and
that
the
stage.
claim, no, I was about to point out, the claim petition filed before the labor court, not a whisper that I am willing to go to Bangalore.
No, but in any case, but you filed a response.
No, we have
It
not
was
filed.
stayed
a
at that
No, no,
stage,
we have
no.
not filed a response. They filed a claim statement and then my lord, we came before this court and there was a
See, sir, what she says.
claim statement, my lord.
Claim statement is.
Yes. 275.
Yes.
Nothing in the claim statement either. It doesn't take the case forward at all.
There's no response to this.
Not yet, not yet, not yet, not yet. Claim statement is at page 275. In fact, my lord. Yes, yes, yes. Not a whisper in this claim statement that one cannot survive without the other, that I am willing to go to Bangalore. Nothing. That in fact, the Tumkur unit has not been de facto closed. They have closed the front door, they're opening the back door and working there. Nothing, Lord. I mean, all this on law, my lord.
There's indications, Mr. At this page which she had read, at page 251.
Yes, my lord. 261. 251. Yes, my lord.
They have adopted standing orders.
No, standing orders are the same. There's no difficulty about it. It is one balance sheet, one income tax. Where is the question, my lord? But it is two factory licenses. One factory license has been surrendered, not in dispute. Maybe, my lord. If somebody requests for transfer, they may be transferred. We may say, okay, come. Doesn't matter, my lord. I will assume that. I will assume that against myself. That doesn't make it functionally integral. It has to be, my lord. One does not survive without the other. Yes. Yes.
A, B working in Bangalore, C, D working in Tumkur. A, B may be joined prior to C.
Exactly, my lord. Seniority, common seniority list will be maintained.
What you are doing, closing Tumkur and continuing the juniors, removing the seniors. Would not that will be a grievance insofar as those seniors?
No, my lord. No. Assuming that my closing Tumkur unit is aimed at, let me assume without considering victimization of an employee. I said these Tumkur employees are very troublesome. Let me close it. Even though Tumkur is a very profitable unit, that is my prerogative.
But in that,
Therefore, Manoj, that I keep the juniors in Bangalore, I get rid of these persons who are senior in Tumkur. I will assume, Manoj, that it is with a mala fide intention. I will assume that against myself without conceding. That cannot be an industrial dispute. But the law is now quite clear, having regard to the law laid down by the Honorable Supreme Court, my lord, in pottery and, my lord, clear.
that particular spectrum also denotes a functional.
There should be therefore a prayer by them saying, please take me in Bangalore. I am willing to go to Bangalore. And that is a core of this prayer which they make. They don't want all that. There, in fact, their case is Tumkur is not closed.
No, but what is being argued? That's a reason.
Argument, I understand.
No, we have put the reference. What she says is, if suppose for a moment the E is accepted, interchangeability, integrality, you may argue functional integrality will not come in the facts of this case. Suppose for a moment the tribunal says, very well, there is a transfer, interstate transfer of the employee from one unit to the other. To that extent, there is a functional integrality. If that be so, then what the terms of reference is, you provide employment because of the closure of Tumkur.
There should be a scope for that investigation. I am not talking about finding. There should be a scope for investigation under the order of reference. There is none. Your lordships. Scope, I'm not on the question of whether there is a basis for the finding, whether there is a scope for investigation. That your lordship will do it. I am on that, my lord. Of course, my lord, I'm not asking your lordship to grant me a finding on merits. But that there is functional integrity, there is no functional integrity, there can't be shifting from Tumkur to all that your lordships, my lord, I respectfully bow down will not do. But is there a scope for investigation having regard to the terms of reference? That is all that I'm saying.
That scope, if that scope, surely we will not go into it. We will leave it to the tribunal.
Yes, 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 yes. Yes, my lord, yes, my lord. On whether de facto, your lordship will not go in. But if there is no scope for such an investigation itself, your lordship will interfere, saying, where is the dispute in this case for reference? And even though it is an administrative order, the government is not a post office. They have to apply their mind. And today there's not a material before your lordships or before the learned single judge as to what material was considered by the government before they made this order of reference. Nothing. It is for the government to tell you, to have told this learned single judge as to what material, what is the basis on which this order of reference was made.
They're required to file it. Do you think before the government for them to take it?
No, government must do it.
No.
Government must do it. No, I don't expect that to be a encyclopedia. No, my lord, I don't. It's like a complaint before a police station.
And for the court to look at
No, the government must look at it. The government must say, look here, what are the aspects which went into our thought process, which led to our making a reference of this kind. It is not mechanical. And today, my lord, there is no material has been produced before the learned single judge by the government. I don't expect my learned friends client to do it. Of course not, my lord. They are not the custodians of the record. The government should have produced it. Obviously, they have nothing. It is all done, my lord. In fact, this is one of the reasons why our labor courts and industrial tribunals are cluttered with cases as our magistrates courts are cluttered with complaints. Though, my lord, I understand that 482, your lordships are very circumspect investigation. But today, my lord, we come to a stage when courts have recognized also that unless we look at it, we read the complaint between the lines. You might as well quash it because pendency in the magistrate's court will reduce. Otherwise, my lord, is becoming uncontrolled. Every litigation, every civil case becomes a criminal case. So therefore, my lord, if really as a matter of policy, we want to ensure that real industrial disputes go to the labor courts and industrial tribunals for adjudication, then, my lord, the role of this honorable court, it is my humble submission, to look into the reference and find out, in fact, is this an industrial dispute or not? Are we unnecessarily burdening the labor courts and industrial tribunals with all kinds of cases, and therefore genuine cases are not? Yes.
say more.
Yes.
We'll come back up.
Please.
Serial number 12.
I'm for the responding number.
We are here for whom? What is the issue here? You have it somewhere. Please give it in.
That's okay.
5-8, sir.
Nothing else. Case number 2, page number 48. Lots of directed to filing a memo for clubbing the other appeal matter.
Not here. You will file there. Before the court concern. Here. Okay. We have given you date. On that day, you file it. So where is Mr. Shankar had, yes. What is the difficulty, ma'am?
Today we have some inconvenience, maybe for the afternoon.
I'll be in Harvard tomorrow and after.
Or any date after the fifth, my lord.
Could it be 26th Friday?
When do you want?
He did after fifth, my lord.
No, sorry, sir. I forget the facts. I'm 8. I
No,
forget the
Mr.
facts.
Shankar, you should not say so.
So please. Have it at
Yeah, we'll have it at an early date. What is your convenient date?
26th or 30th.
Yes, please. See the board.
30th, sir.
38th.
Let you know.
Thank you. We'll come back.
With a kind permission, my lord, there's an urgency in the matter. Lordship, kindly, there is a PAL was filed before the Apex Court. In respect of the Mangalore, there is a landslide. The Honorable Apex Court has given a direction stating that before approach before this Honorable High Court, and make a mention regarding because person is found to be missing in the landslide on 16th onwards. Till 19th, this mobile was in the working condition. Now there is an urgency is the matter to save this person's life. Intervention of the state as well as the army, the union is very much required because till 19th he was supposed to be alive. Now there is a lag on the part of the state to expediently take up this matter. So in the meantime, this was informed just now from a counterpart from the Apex Court to make a mention with the Honorable Court. So meanwhile, the Lordship permits, I'll place necessary records by afternoon, at least a petition copy by 2:30, my lord, permit me to serve the copy which is filed there, so that this matter can be taken as a PAL itself.
When?
The afternoon, I'll place necessary lordship to take it forward because it's a question of somebody's.
So when did the listing?
Afternoon itself, I place a record, by in the formal petition, I file it. Illa.
The Chief Justice is sitting, not here, but he is sitting in.
Lordship, due to the urgency of the matter.
You make a mention by, you can
Virtual.
appear virtually.
You can mention there, virtually before the Honorable
Because
Chief Justice.
PIL has to be made before the Chief Justice court only.
This Honorable Court is in charge of that court.
We are in charge of only this list. This list.
I make a, please, my lord.
Mention it before the Honorable Chief Justice. You can join virtually.
Please, my lord.
Then see the matter. Mention it. The PIL shall before the Honorable Chief Justice.
Please, my lord.
Before that, you approach the Registrar Judicial, so that he can.
I'll mention it. Please, 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 my lord.
Because if he is not sitting, then definitely we can say.
Please, my lord.
But he is sitting.
I'll make my attempt, my lord.
He can appear through virtual.
Please, my lord.
You can do that.
Please, my lord.
Thank you.
Madam, serial number 19, madam, list number 2. Madam, list number 2, serial 19.
I just want to. That's right.
Yes.
I want to reply, my lord, to 4 new contentions raised by them. So I just will make my short reply on those aspects. The first is that I ought to have sought for a reference under section 2505 of the Act. No, my lord, that I ought to have sought. That was his argument, that I should not have gone under 10. I should have sought under 2505. My lord, that itself presupposes that he is fine with adjudication of the matter. He is saying I should have adjudication under a different section. My submission, my lord, is 2505 will not at all apply in my case because there's been no permission application made by them. If 2505 is referred to, it says the appropriate government may, either on its own motion or on the application of the made by the employer or workman, review its order granting or refusing to grant permission or refer the matter to a tribunal for adjudication. So it's only when there's an order which has been passed granting or refusing to grant permission, then I can seek a reference under 2505. Here they never. Please. They have not granted. No, that's actually not a correct reading at all because prosecution is attracted under 25R, not 25O. So 25R gives the penalty for prosecution and that entirely goes under 25R, my lord. 2505 is for adjudication where permission is granted or rejected. It's not a penalty at all. Yeah. This is. So this is not on the order which they refer to. That order is an order under 25R. It's a penalty order. This is a reference on the order application made by them for permission, which is not even made in the instant case. Prosecution 25R. My lord, R is the penalty for violation of 25O. Uh, 25R is the penalty provision. 25O is my submission is applicable as soon as you exceed 100, you are mandated to apply for permission. The management. Yes. No, they are involved because how it works is that 25O application is given. Under clause 1, notice goes to the workman and an order comes to be passed after hearing both sides, granting or refusing to grant permission. Now, if the workman is aggrieved by that order, then I can seek reference under 2505. But that's not the situation here at all. This is not a case where application has been made and it's been rejected for me to seek reference under 2505. Yes. That's exactly my case, that they have not filed an application at all. Sorry, my lord. Exactly. Yes. Prosecution comes under 25 hours subsequently.
And that permission is granted.
Then I can seek reference as my learned friend said. Under 2505. Yes. 2505. But here they have not even filed an application, and 2505 specifically says it's only where it's granted or rejected and you're aggrieved by that, then you can seek reference under that. So here they have not even filed the application. So if I had filed such a reference, they would have come and said that it doesn't even fit within the explicit terms of the section. Only if I'm aggrieved by an order rejecting granting permission to them, then I can go under 2506. Yes.
The matter can be referred to-
Only,
Can be referred for adjudication.
only in respect of the order granting or refusing to grant permission. Here, there's no such order.
Please,
Or,
management
yes, yes,
or abuse.
yes,
The petition is granted to those who have
I can
abused.
go. Otherwise, he can go.
That's what is being said by. Friends, this case. Although your case is that you filed it under 25R.
Penalty, I filed under 25 hours.
Why anything, you could seek any referral under 25R.
My lord, that is precisely my submission. I'll say it again, that the scheme of 25O mandates that if you have more than 100 workers, you file an application for permission. After issuing notice to the other party, an order comes to be passed. If I'm aggrieved by that order, then I can seek a reference under 2505. Here, they have not sought for permission at all. On one side, I raise a dispute under the ID Act regarding violation of 25O, F and G. And on the other hand, I also apply for penalty provisions under 25R. 25R goes, my lord, there's no doubt about that, and I'm not aggrieved by that here. In respect of the reference under 25O, the terms of the section itself say that 2505 is applicable only when I'm aggrieved by the order which is passed, and there's no order which is passed at all, granting or rejecting permission, because there's no application made by them at all. That's the submission on 2505. So there's no reference. Exactly. So which is why then this 2505 cannot apply to me at all. Then secondly, my lord, there's no application at all. Then secondly, my lord, is the submission made by the management, my lord. My submission, it's an unconscionable argument, my lord, by the management that even assuming a senior worker is victimized and removed, and even assuming there's functional integrality, even then he has no remedy. And the answer to that, my lord, forms part of 25G, which I've also claimed violation of in my dispute. 25G, my lord, lays down the rule of G, my lord, lays down the proposition of last come, first go, which is a settled proposition of labor law. Once, my lord, I establish functional integrality, then they have to remove the junior most workman here. This is not a case where on misconduct, they can remove whoever worker they choose. But if there's a common list, my lord, then then the management, exactly, once I establish functional integrality, they have to maintain a seniority list. And on the basis of the seniority list, they remove whoever they want at the bottom. That's what has to be proved before the tribunal. Let me. Please.
You will not make the reference or reference should not be acted upon merely because you saw a reference. Ultimately, they know interest.
Yes.
They can come to the court saying.
Yes. Yes.
And mind it, the labor court or the tribunal will not go into the issue whether they will.
That it cannot be done.
Suppose there is an industry.
Please.
Patients are taken, there is no industry.
In that case.
Semblance to say that there is an industry.
Yes.
It needs to be adjudicated.
Yes.
If the court, the exercise of physics will not go into the same merits and decide what.
Yes.
Semblance, yes, there is an industry.
Now the question of what is a dispute then arises. And in that respect, I rely on the judgment furnished by my learned friend in his first memo of citations, dated 5/7/2024. I refer to ANZ Grindlays Bank. I refer, my lord, para 11 at page 41, which is of ANZ Grindlays Bank. Can I read, my lord? Para 11 at page 41 of the first citations. The principal issue which requires consideration is whether the central government was justified in making a reference to the industrial tribunal in terms set out earlier. 2K of the Act defines industrial dispute, and it means any dispute or difference between the employers and employers, or between employers and workmen, or between workmen and workmen, which is connected with the employment, non-employment, or the terms of employment, or with the conditions of labor of any person. The definition uses the word dispute. The dictionary meaning of the word dispute is to contend any argument, argue for or against something asserted or maintained. In Black's Law Dictionary, the meaning of the word dispute is a conflict or controversy, especially one that has given rise to a particular lawsuit. In Advanced Law Lexicon by Ramnath Iyer, the meaning given is claim asserted by one party and denied by the other, be the claim false or true. The term dispute in its wider sense may mean the wranglings or quarrels between the parties, one party asserting and the other party denying liability. In Gujarat State Cooperative Land Development Bank Limited, it was held that the term dispute means a controversy having both positive and negative aspects. It postulates the assertion of a claim by one party and its denial by another. Now, my lord, in this context, this is a dispute pertaining to my non-employment. I have made a claim. He has made a objection, which means in its terms, it's a dispute. The merit of it, of course, is not something even my learned senior will say that in Telco, Supreme Court clearly says the government cannot look into the merits of the case. Have I made a claim? Have they rejected that claim? It means it's a dispute. Yes. Yes.
You can see dispute. It's a closure per se, if it is an accepted position, is not justifiable, I do not. That's the one.
Please, my lord.
Submission is the difference which is sought presupposes is based on closure.
Yes.
Is based on closure. And if it is based on closure, which cannot be, could not have been indicated, or in view of the judgment, then the reference. That is, you are right. You say something, the other party will say something. Minus closure, what is the dispute?
Minus closure, the dispute at its core is what my lordships mentioned, that if I prove functional integrality, I am, as a senior workman, I am entitled to be working even today. And 8 years it's been delayed because stoppage of the reference. The case could have been concluded by now. The core issue is, as a senior workman, under industrial law, one workman is treated as another. There is no scope, as my learned senior mentioned, that even if I victimize them, even if I remove the senior person, even then they cannot do anything. That, my lord, is contrary to the letter and spirit of the act, because the letter says the senior workman will be continued, the junior workman will be removed.
No, which letter?
Please?
Which letter, which document?
25G.
That's within the statute, but how do you translate your facts to that provision?
My lord,
Based on what evidence?
I'm saying my right to adduce evidence should be maintained. I will prove the evidence, my lord, but that can't be at the stage of dispute that all my evidence has to be given to the government and only then the reference will be maintained.
That's what you're saying. You will not everything say, but you have taken a particular stand.
I'll prove my evidence.
Transferability of
Yes.
one unit to the other.
Yes.
And you say there is a common standing order.
Yes.
What is the effect thereof in law will be determined by the tribunal.
Exactly.
That's what you're saying.
Yes. Then the third proposition, my lord, is the last point I want to make, is on the new citations filed by them just today, my lord. The first citation, my lord, I apologize, I'm not finding it. The first citation is distinguishable on the grounds that of para 14, I believe, which says 13 or 14, my lord. The second last, I apologize, my lord, I gave the citation to the government. The first citation. Yes, my lord.
Yes.
The first citation, if para 12 is referred at page 8, there, as my lordship mentioned, it's a case where the union was arguing that contract workers have to be considered. And the court says there's less than 100 admittedly. So it's on an entirely different footing as my case, my lord, because here I'm not saying that there's no admission that there's less than 100 permanent workmen on the rolls. The second judgment, my lord, which my learned friend referred to, was a challenge to an award passed. So that is after adjudication, the court comes to the conclusion that there's no functional integrality. But here I've not had an opportunity to adduce evidence, my lord. That's all, my lord. Deeply
I
obliged.
just want to make one point, my lord. In law, my lord, kindly see 25O. I think there is, my lord, a point that I want to. What was told to your lordship is that only with respect to refusal or grant of permission, that there can be a reference under 25O. 6, my lord, I would respectfully say, my lord, that that's not a correct understanding of section 25O. Please read 25O once again. The appropriate government may, either on its own motion or on the application made by the employer or any workman, review its order granting or refusing to grant permission under section 2, or refer the matter to a tribunal for adjudication. So, my lord, what can be referred to adjudication under 2505 is not simply the question whether the refusal was right or granting was right. The entire matter can be referred. That is the wide width. That's why, my lord, the section uses the word refer the matter. Now, what is the matter here? Functional integrality is a matter. Therefore, when you are passing an order under 25R and you are required to consider 25, the applicability of 25O for the purpose of 25R, necessarily, my lord, it becomes a matter under 25O. Therefore, my lord, 25O uses very advisedly the word matter. Not, my lord, simply the question where permission is granted, workmen can go. Permission is refused, management, of course they can. But in a situation where it is a case of 25O's applicability being determined under any other provision, then the matter, namely as to whether it is one unit or two different units, which is what is the core of a consideration under 25O, can be referred to. So therefore, it was very much open for the workmen to say, you have come to a conclusion that these are two independent units. You have come to a conclusion that this is not 100 plus. Therefore, we don't agree with it. Please refer this matter to the industrial tribunal for the purpose of adjudication as to whether it is one unit or two different units. That is the scheme. But it would be back wages only. Can't help it, but that's a law. That's a scheme of the statute. In fact, 25F therefore also will not apply. What my learned friend referred to, my lord, is not applicable because that is a case of retrenchment. 25F. 25F doesn't, when I'm closing the whole unit, where is the question of, I'm sorry. 25F, my lord. My learned friend referred to 25G, I'm sorry. 25G is applicable, I'm sorry, I apologize. 25G applies in a situation of retrenchment, where I have 100 people or I have 60 people, I want to send 20 people home. How do I find out who those 20 people should be? Yes, it is in that situation, not where I say I want to close down the entire establishment. 25G will not. Where is the question, my lord? Where is the question of saying that? No, my lord.
When there is a reference under 25(6), you succeed, consequence would be, suppose if you went to the illegal way, then they should have it, you should have it. Now, you can't keep it for various. You are entitled to that.
No, even 2506 says I'll get continuous as if I've never been terminated
Right.
at all, which means I'll get
That
it
is
till
the-
I
that is
retire.
the they are not remediless.
Exactly, my lord.
No, my lord, no, my lord. In a reference under 25O, the scope is different. In a reference under section 10, the scope is different. In a reference under section 10, in a reference under section 25O, please see subsection 6, where no application for permission is made under subsection 1 within the or where permission has been refused. Closure of undertaking shall be deemed to be illegal from the date of closure, and the workman shall be entitled to all the benefits under any law for the time being in force, as if the undertaken had been not been closed down. Therefore, they are entitled to say, I am in employment. Yes, that is it. That cannot be said if there is de facto closure and a reference as to legality is made under section 10. The question of legality is outside the purview of a reference under section 10. But the question of legality of a closure, even if it is de facto, is available under 2506. That's the difference, my lord. Otherwise, there's no mean. 10. Yes. Yes. Yes, my lord. Well, no. Therefore, the remedy is only under 2505 and read with 6.
This is your stand, Mr. Rao.
Yes, my lord.
Then why don't you seek a reference?
That is a different matter. Let them do whatever they want.
Let
That
his
is a
statement be
different-
placed
This
on
reference
record.
must go. What they do is a different matter. Then, my lord, that's a different matter. Let them
We'll
do it.
challenge that then as well, my
They
lord.
let to do it. I have no problem. If they do it, my lord, I have my other defenses. I will take whatever other defenses I have. I am not going to disclose my cards today. Today, this reference must go. What other remedy they have? Of course, my lord. That's
Right. So that they have to follow a process.
Yes, that's a different. They must, because this is a very important step in the scheme of the Industrial Disputes Act. Otherwise, my lord, there is no logic in having two separate routes for reference. One under section 10, the other under 25O. General provision. Subject only, my lord. Insofar as closure is concerned, it is very limited.
You can say that's what you have been saying so much. So, then is the general provision for reference. When it comes to a specific provision for reference with regard to closure, it is this.
Yes. And that is very importantly, my lord, even where the closure is illegal, but de facto, still relief can be granted under 2506. But if a reference is illegal, but de facto there is a closure, there can be no relief under section 10. Yes, if de facto there is a closure. That is why, my lord, the matter has to be referred. The matter is with regard to the legality of the closure. Suppose, my lord, I say I am doing it mala fide. Well, my lord, it may be illegal because anything which is mala fide is illegal. Therefore, they may be entitled to go and say, refer the entire matter under 2506, 2505, read with 2506. That would be the subtle and, according to me, the important distinction between a reference under section 10 and a reference under 2505. Otherwise, I see no logic in having a separate provision like 2505 and using the word matter. It is not only the question of whether permission is granted or refused, the entire matter can be referred. My lord, to the best of my, I have not been able to find, my lord, but I shall keep my search, my lord, is such an ocean of knowledge. I will keep, if there is anything, my lord, we'll place it before the court master. Yes, that's right. But this whole thing has not been looked at by the learned single judge. Of course, my lord, I must say, maybe we didn't put it before by the way in which I am now placing it for your lordship's consideration. Maybe the fault also lies with us, my lord. We ultimately, the honorable judge will decide in the way in which we put the case.
Yes, then reference goes to 152. So the way you are trying to put it between the difference that then one is 25 next to 25 specific to closure. And what can be the scope of application of the reference in the 10, and what is the scope of reference the 25
My lord, on a much lighter vein, my lord, Justice Krishna Iyer, who we revere because he is our icon of labor law and we practice labor law. He says in L. Michael's case that to hit below the belt by trading industrial technical phases is not industrial law. Industrial law is to protect the workman. So I leave it at that, my lord.
In fact, there's another fundamental way of looking at it. Please ignore the order that is passed by the Chief Secretary. Let us forget about 25O, let us forget about everything. Manoj, they are stopped from today contending that the unit has not been closed, either on the principle de facto closure or on the principle of functional integrality, because they filed an application under 25O. They filed an application under 25R. But look at their conduct. All this discussion, Manoj, according to me, my lord, in my humble submission, is academic. Let us look at that. Let us assume, my lord, that this order was not there. They made an application in 25R. 25R, my lord, presupposes that there is a violation of 25O. 25O presupposes there is a closure. If there is functional integrality, there is no closure. If de facto there is no closure, there is no closure. When the moment they make an application under 25R, they cannot contend that de facto no closure of Tumkur unit or about functional integrality. Yes.
The ground on which they are sought a reference on the 10 and
Same.
the application is
Same. That de facto there is no closure or functional integrality there is no closure.
But let's assume for a moment they 25 are all that.
My lord, then I have to work out my remedies. Then, my lord, there's a problem for me. There's a problem for me. Today, I am not in that situation. The problem is with them. 25R application has been rejected.
No, but if it is accepted, it could have been accepted on the ground.
Functional integrality or de facto no closure. One of two. One of the two. Or either de facto no closure or functional integrality, therefore no closure.
Yes.
Then you would be entitled to the benefit under 2506 or 2505 or 7.
No. Usually, in
6,
fact,
2506.
But in fact, how it works, my lord, is that even then, even if I'm entitled in law, I don't get that benefit automatically. It's not that even if I get a prosecution order, what happens is that maximum they go to jail for 6 months, but it doesn't mean that I automatically get the benefit. I should get. I seek a reference and I say, give me the benefit.
Get an interim order. Get an interim relief.
Yes, you seek a reference.
Yeah.
And they must seek an interim relief and they must seek a reference and seek for interim relief, which is permissible. It can't, the Industrial Disputes Act gives a special right, which the common law or the statute law does not provide, because the concept of enforcing a contract of personal service is foreign to law. The only exception is Industrial Disputes Act. If the right is created by a statute and the remedy is provided by the statute, all other ways of enforcing it is barred. It is Dunawai's case will not lays down that. Yes, but all those. So how can they now say, oh, look at this Industrial Disputes Act, I have a remedy, don't make you. No, the right is provided, remedy is also provided. Beyond that, there's nothing else.
Thank you.
Grateful, my lord. We are grateful to your lordship, my lord, for the very patient hearing, my lord. I must, my lord, before I owe a duty to my learned friend. My lord, I must say, absolutely, my lord. In fact, these are the silver lining in the cloud. In the cloud. This, my lord, this type of advocacy of my learned friend, thoroughly prepared. Exactly, my lord. That's what, I mean, my lord, what happens in the case, ultimate result is of no, but that, my lord, I was watching what she was doing with great admiration, I must say. My lord, facts, law, style of presentation. My lord, if she proceeds in the same way in which she's doing, my lord, there's future for advocacy and more particularly for lady advocates. My lord, grateful, sir. I am grateful.
Number 3. Serial number 1, Shri Venkat Subbarao.
Can you pass on, madam? Can you pass on, madam? Please.
Serial number 2, Shri Sanjeev BL. Serial number 2. Serial number 2. Serial number 3, Government Advocate. 4, Shri Shivram Bhatt. 5, Chandra Reddy. 6, Shri Mangal Das. 7, Shri Kashyap Naik. Serial number 8, Shri Mahesh. 9, Shri Ismail. 10, Shri Pradeep
Then
Kumar.
in this case, I am afraid for the appellant, my lord. We have produced the inquiry proceedings on 2/7. It has come before this corner court. I will produce the translated copy of the one document, my lord. It is Kannada translated copies. 10. Yes, my lord. In the inquiry proceedings, there is one reply given by the. Oh, please, man, no. Yes.
No, only we are here.
14, which
Complaint
list?
listener.
Sir, which list, sir?
Complaining.
List number?
List 2.
List 2 is what? We are telling you list number 2. ಬೆಳಗ್ಗೆನೆ ಡೇಟ್ ಕೊಡ್ತೀವಿ. Serial number?
Serial number 14.
Yes, sir. 2 names.
29. May I make a request, my lord? No, not for the data. The matter may be listed little higher on board. On 4 occasions, the matter was posted and not. Two nine. Not the 2 9. 2 9. All right, much okay.
Mahesh, sir.
And the appeal was filed, appeal was allowed in my favor, appellate authority. Since that was not implemented, I approached the Disarm Court. Disarm Court to implement the orders of the appellate authority, to reinstate with backways. Myself responded. Prior to implement the orders of the appellate authority, wherein the order granted. They have come in appeal. The reinstatement full backways was ordered. And the reinstatement was made only with regard to back wages, that was some court state. That has to be. There are some misappropriation that was not proved. Not proved. Bill collect. That was the charge, that was not proved. Instead of challenging the orders of the appellate authority, they have challenged the order of the land single. Yes, that's true, but neither they have implemented nor reinstatement was made. Only back wages, yes. I leave it to last. I leave it to last. Some, of course. Twen- 20, 70. Very. Mahesh and Ashok. Mahesh for Panchayat and Jilla Panchayat Ashok Naik. That list was the big, you lost. Regular list you lost, I have to mark. In the regular list, if it was in. Very well. They have to, very.
24, sir.
Yes.
Parted matter in another madam. First matter madam. Near engage in another quarter madam. Tomorrow I have seen. Parted matter ನಡೀತಿದೆ ಮೇಡಮ್ ಅವಾಗ. For 12 ಅಲ್ಲಿ parted matter commence ಆಗಿದೆ. Late ಆದ್ಮೇಲೆ. Take up on tomorrow ಮೇಡಮ್. Please. Please.